With me, Brad Micklin, trial attorney. Let's dissect this for a minute and talk about why. Okay, another thing to point out, just for the viewers, this is a different jury, but the same prosecutor. So the prosecutor that was found of misconduct in the first case is now going for the death penalty again in the second case, but it's a different jury. And this jury is not the jury that actually found him guilty of the murders. This is a rehearing of just the death penalty. So now the jury has to rehear all the facts and evidence all over again. Why is that important for a death penalty hearing?
Well, I think it's important because every aspect of a death penalty case has really heightened scrutiny from the beginning appointment all the way to the sentencing. And here we have a case that was returned by the appellate division, actually was first denied and then reconsidered and then returned. So there are a lot of people that have a lot of interest in making sure this case gets done right. First of all, of course, the prosecutor, but then we have all the victims' families and all the relatives and friends and everybody that's getting involved all of these years are part of the trial that we're now trying to conclude for once.
And do you think it's necessary for a serial killer of this magnitude who's been, or he's admitted 5 killings, to have to go through a sentencing rehearing real fast? We have to take a quick break. Yes or no?
Well, unfortunately, yes, because the appellate division said so, but I don't think so. When you have 5 murders, there's no question.
Right. It seems like there's no question. Seems frivolous, but due process of law is important. Welcome back. This is the death penalty sentence rehearing for Anthony Kirkland out of Ohio. This is the case where the serial killer was convicted and sentenced to death in 2010. But because the prosecutor said in closing arguments that even though he was already sitting in prison for 2 other murders, life in prison, that if they didn't find him guilty and sentence him to the death penalty, that the second set of murders, there's 5 total, would be considered freebies. With me, Brad Micklin, trial attorney. Let's talk about this. Right now we're listening to some draconian testimony of the police interview where he's walking through the admission of these murders. Why is it important that the jury hears these admissions blow by blow, even though we already know he's guilty?
Well, because again, this is a death penalty phase, so the important issues to establish are going to be aggravating factors.
Exactly. Like so aggravating and mitigating. So by explaining this, he's going into the the jury is going to decide if it's aggravating rather than the prosecution saying in closing arguments that this is aggravating, which is more conclusory.
Right. But also remember, at the time he's taking this interview, this is before all this has happened. You know, we sit here talking about the appeals and the hearings. It's all very intellectual. But this is earlier when he's just getting the confession. And my understanding was Kirkland was in and out of questioning for many years on these murders. So I think it's very important at that point in time that they get the admissions and the statements very clearly on the record.
Right, and I think that's a good point, too. So for those of you just joining us, this was a 2010 sentence to death. We are now in 2018, 8 years later. So by replaying things that were fresh at the time, the jury gets to hear things from a perspective back then, even if the defendant were to take the stand and say anything fresh right now. Welcome back. You're watching the Anthony Kirkland trial out of Ohio. Now, you might be watching this and thinking, it's kind of boring to listen to all this testimony and this police interview being played. It glosses over the aggravating factors. I mean, imagine if this was actually really told and you were watching it as a movie, because this guy killed 5 people and he is going through in a very dry manner 5 different murders as he admits them in this death penalty trial. With me, trial attorney Brad Micklin. Brad, let's discuss this. When we were on break, you and I were chatting together on set saying, you know, something that's actually rather colorful is kind of boring to listen to. And we were thinking, what's the jury think about all this?
It's very trying. I mean, I think sitting on any jury is very challenging because while we get to see the exciting parts and the parts that go on long crime or the exciting parts, there's a lot of monotonous testimony, there's a lot of downtime. So here we have people that are sitting listening to a recording because it's a new jury. And you're right, he's talking about, now I think we're on the 3rd victim. And you hear things like how he dragged her, and that's compelling. But then you get into little things like what was she wearing and what time of the day was. And it's very challenging, I think, to follow.
It's so easy to check out. I mean, it's so easy. I almost wish that the cameras were going not only to the transcript so we could understand and see, but to the jurors' faces as well so we could get perspective on what they're thinking and how they're actually digesting this. Because if this were a movie being replayed and enacted, there's no way that we wouldn't think that this had severe aggravating factors. You have a minor, you have minors, plural, you have arson, you have murder, you have serial murders. And then you have a very dry transcript recounting this to decide whether or not he should be found guilty of the death penalty or sentenced to death. Welcome back. This is the Anthony Kirkland case out of Ohio, the death penalty resentencing. Remember, he was sentenced to death in 2010 after he was found guilty of a total of 5 murders. He's a serial killer. The prosecution said that if you don't sentence him to death on these last 2 murders, that they're basically freebies because he was already serving life in prison for the previous murders. With me is Brad Micklin, trial attorney. And Brad, we were discussing during, break and during while they're in trial, how dry this sounds right now. But then we were going into the aggravating factors. And I think one thing to point out that the audience needs to know is that not only is this a serial killer with 5 victims, but there's a common theme. And what's that theme? They're all women. There's sexual assault involved in all of them. There's arson involved. And we're here listening. Oh, and there's minors. Okay, talk about aggravating factors. And here we are listening to a resentencing hearing of a death penalty case. Really?
You can't get around how gross these offenses were, and whether you're talking about aggravating or mitigating factors, there's no way to escape it.
It's so aggravating, though. Mm-hmm. How can this be mitigating?
I don't think you can.
The only thing to me that's mitigating when I listen to this is the fact that we're listening to a very dry transcript, and it'd be so easy to check out and not pay attention and catch these aggravating factors.
Well, but you also have to look at Ohio statute that will actually delineate which is and is not an aggravating factor. And most of them are, but I think the jury is going to have trouble separating them anyway.
Well, because the jury's human,
right,
and the jury's going to have their own human influence on this. The only disadvantage that the jury is going to have on this is the fact that they're not listening to the actual trial. They're listening to the resentencing, whereas the initial jury that sentenced him to death, they had the benefit of hearing the first trial and then sentencing to death based on that. Lisa Kenny, the mother of Esme Kenny, that is a mother who is never going to forgive herself for not going with her daughter to go for a jog that day. 13 years old. She just wanted to go for a jog outside the house. She asked her mom to go, but the mom was too busy cleaning up drywall. This mother had a maternal instinct, and she will never forgive herself, as you listen to that testimony. With me, trial attorney Brad Micklin. What are your thoughts about this, and what do you make?
Well, there's a lot. I was first taken by how calm and cool she is when she's recalling this tragic story, because while all of them are tragic deaths, this was probably the worst and the youngest victim. But then I realized it's because she's been through it for so many years and probably told the story a dozen times that it's almost routine for her, and I think she's just trying to get through it.
Right, so she's trying to get through it, but the jury also needs to get through it, right? The jury needs to hear this because this goes to the aggravating and mitigating factors on whether or not the death penalty is an appropriate sentence. Right now, there's 2 victims for this trial, right? He's guilty of killing 5, but he's already serving life in prison for the others, and he was already out, before on another death that he caused, and then he went out and had 4 more murders, serving life in prison on the others. Then there's these final 2, and right now the jury needs to be walked through this testimony with Esme Kenny, or the mother, Lisa, and the other victim, because the jury needs to decide, is this aggravating enough to have a death penalty sentence imposed?
Well, and I think this case and this testimony is probably the most important, because while they're all gruesome, when you look at Ohio's aggravating factors, the age, I believe, for one of the factors is 13. So Cassandra was 14, but Esme was 13. So this is really crucial that the jury get to hear all of the factors behind this death.
Right. So even though 1 year off is considered not aggravating according to Ohio statute, like you said, you're still dealing with a 13-year-old and a 14-year-old, which is, if anyone's human and they're sitting on that jury panel, they're going to say that's aggravating. Plus, they were sexually assaulted. Plus, they were burned.
Yeah, I don't think the jury is going to be able to separate these factors and say, well, Cassandra was 14, so that's not an aggravating factor. I think when you murder and burn a 14-year-old, there's no way to escape that.
And one thing I have to say that I think is a shame is the fact that our judicial resources need to be wasted to retry this when a guy like Anthony Kirkland is so guilty. He is so guilty. We know he did it, and he was sentenced to death, but we have to expend our resources because the prosecutor said one line passionately because he was upset.
There was actually several issues that the appellate division had with the prosecutor's statements. There may have been 3 or 4, but they were all just as small as this one. And I don't think even in the aggregate that they could have or should have remanded this for another trial, put all these families and victims through it again.
I totally agree they shouldn't have remanded it, but here we are, they remanded it, and now the victims are going through it again. A new jury who doesn't even get to hear the initial trial is going through a mini trial to decide the sentencing. And because of that, this guy, who is clearly a monster, may get away with these freebies after all, which the prosecution was that's why he got in trouble on the appeals. But that's almost unfair, because as a prosecutor, I know when I was a prosecutor, I was so concerned with closing arguments, because it's so easy to get a mistrial if you say one thing wrong when you're talking off the top of your head to try to piece it together for the jurors to make final argument. You have to piece together that narrative, and he pieced it together, but he made a conclusory statement, which then caused this whole trial to be reheard for sentencing.
And you can understand that. I mean, if you're, as you said, you're a prosecutor. I never was, but I can. I can't imagine that if you're facing a serial killer that you're trying to convict, you're going to be a little overzealous at moments. I don't think you can control it, but to return it for such what I think are benign statements was just ludicrous on the appellate division.
Yep, I totally agree. It shouldn't have happened, but it did, and that's our justice system. Testimony from Sergeant Jennifer Mitch with the Cincinnati Police Department, and she is the responding officer discussing the DNA that she found on scene on the defendant, which links also to the victim, the final victim, Esme Kenney. With me, Brad Micklin. Why is this critical testimony? Why does the jury need to hear this in a sentencing phase of a trial? We already know he did it.
Well, a couple of reasons. One is, again, Esme is one of the most aggravating cases under the statute to go for the death penalty. But there was also a lot of controversy as how the police handled this. Right. But also there was controversy about how the police handled it as more of a missing persons and not an assault or murder. So I think you'll hear inside of this officer's testimony, there's a little bit of explanation. There's testimony about they didn't release the dog because they were afraid she was going to get bit. And I think they're really trying to justify some of their actions and some of their lack of actions so that there's not a lot of upset.
Well, and that's a good point, because there could always be a civil lawsuit that follows by the family or the mother saying that had the police responded properly, that her daughter may still be alive, which could be a money play for in the civil arena. Really interesting, testimony. We're going to continue to watch that. But Brad, I want to thank you so much for your time and joining us today. I know you have to sign off to go practice law.
Thanks for having me, Chris.
Yep, great to meet you.
You too.
Take care.
Wallace Bradshaw defending himself. He faces 18 years in prison if convicted of these really bizarre crimes in connection with a bizarre scheme to hire another district attorney's wife and pay her $48,000 for work she didn't do. And he is trying to appeal to the common sense of the jury in his closing argument. And I want to see if that was effective from our very special guest, trial attorney Brad Micklin. Brad, good to see you.
You're getting it right this time, Jess.
I'm going to ask you the same question that I've asked everybody on this case. Does it make sense to you that he didn't get any money for this scheme, that he worked so hard to protect Cindy Blitzer and Craig Blitzer and make sure that she kept earning this money? He didn't gain anything from it. She said she wanted to resign, and he said no. What am I not getting here? Something about that doesn't make sense, and you heard the flavor of it in his closing argument.
Yeah, and I didn't hear much testimony during the case about her involvement, Blatcher's wife's involvement. But we have to remember first, she was still working in the other district attorney's office. But also, from my understanding, the investigation that led to this trial began in part because Blatcher wanted to give his wife, who was then working for his office, like a 30% raise. And that kind of set off bells and alerted some people, so they started investigating it. Then we have this transfer to other offices. So she was, first of all, we don't know what her salary was when she was transferred, if she did or didn't get this raise. But then she was transferred to this other office where she's now working. And the thing about it is, Cindy testified that not only did she not have to work, she didn't have to go in, which sounds like a perfect job to me. I would love a job like that. But can we really believe that he would have given his wife more work, but not to Cindy? If Cindy came into the office, who had, I think, was one case and then no cases,
right,
I can't really believe that his wife was working that hard in his office. And then she was moved to another office just to keep the salary. It wasn't about assisting him in his office any longer.
So you're saying something doesn't add up, right? Something doesn't add up about it. Again, he said, do you think that I would have told her I would have refused her resignation, said I had unfettered discretion to do what I want, and then fire her a short time afterwards. Does that make sense? I mean, what does seem plausible here? Does it seem plausible that we heard the testimony from another individual who worked in the office, Jay Stultz, who was supposed to be the supervisor of Cindy, but then was not the supervisor of her, gave that to Wallace Bradsher. Wallace Bradsher said to him, look, I know you have a lot on your plate. I'll assign it to somebody else. Well, when this whole SBI investigation came forward, Wallace Bradsher called John Stultz in and said, what's going on with her hours? He said, I'm not handling them anymore. You were going to handle them. He goes, I never said that. Wallace Bradsher then authorizes him to release all of her hours to the AOC. And when John Stultz says to him, did she work these hours? He said, yes. What about this, do you think, like, let's break it down really from a practical point of view. This guy's a busy guy. He runs the whole office. I'm sure he's not looking at her day in and day out, what she's working on, what she's not working on. Is it plausible that she tried to reach him and tell him she had no work? Let's start there.
I think it's plausible, of course. I mean, many things would be plausible in a case like this. But I think the important points, which I mostly got from his opening argument, you know, he did a really good, compelling opening argument. You know, he pulled on your heartstrings about his 7 children and how he left criminal practice because he wanted to reduce crime in his hometown. So it was really compelling. But then he goes into talking about all of his attempts to circumvent the policy that prevented his wife from working there. He says, you know, he tried it this way, and then he tried this way. And then what he did, and this is what I thought was the most compelling in my belief of what he did, was he then spoke about what he called mistakes. You know, this was my first mistake, this was my second, third. I remember him getting up to fourth. And I think when you have a criminal attorney who claimed to be very successful as a criminal attorney, who's now an elected district attorney, knows this policy is in effect, and then continues to make what he alleges to be 4 different mistakes, is just not credible. I think he had a strong idea, maybe that it wasn't criminal, because it was an ethics issue in the beginning, but I think he was doing everything he could to keep the situation he had in place. And I think that while maybe Cindy did say that she didn't have enough work, I don't think he took any steps to rectify it.
Do you think he told her not to resign and that he had unfettered discretion to do what he wanted and deliberately tried to cover this up? That's the second part of this.
Well, I think a little bit of both. My understanding from the testimony is that there was state statutes that gave an elected district attorney unfettered discretion over his or her employees. So that's what I think he was referring to.
Okay.
But it then became apparent that you may have unfettered discretion, but it can't be your wife, that's the employee. So it's a separate issue.
Yeah.
You can have a dozen employees and you have constitutional authority over them, but it can't be your wife.
But now we have an update in this case because we heard yesterday the jury, and they're still deliberating the fate of Mr. Bradsher. It will continue Monday. They asked some questions to the courtroom, and perhaps that will give us an idea of where they're headed in their deliberations. So let's talk a little bit more about it with Brad Micklin. Brad, I'm going to ask you the questions. I'm going to tell you what the answers are. Then you tell me what you think about it in terms of where the jury might be going. The first question they asked is, what is the date range for obtaining property under false pretenses, which is one of the charges? The answer gave back to them was jurors were told the offense dates for obtaining property by false pretenses occurred between April 1st, 2016 and October 24th, 2016. What do you think about that?
Well, it suggests that, you know, the jury is probably trying to find out what was happening at a specific time. I mean, obviously they were asking for dates. And I think because there's going to be an overlap, there's issues in this case, not just about the wife swap and the lack of work, but also did he cover it up?
Right.
You know, there was a discussion that he fired an employee that may have been a whistleblower. So I think the jury may be trying to line up these dates to see if there's an overlap to look to whether or not there's guilt or not guilt on certain offenses.
Okay, the second question they had was for count 2, what does representation refer to? And the judge said to apply the common meaning that it may take on many forms. Again, what can we glean from that? And just to let our viewers know, I believe the second charge is aiding and abetting. He's charged with aiding and abetting, conspiracy, 3 counts of obstruction of justice, a misdemeanor charge of failure to discharge the duties of his office, and again, that felony of obtaining property by false pretense. So what do you think about that question?
Well, it's hard to really address that question without the full context of the instruction itself. We're just given that one word. But routinely, in all kind of criminal offenses, the jury is charged with determining a mental state, a mens rea. So that word, that might be a specific definition that they need to find that he, in fact, did either have or act consistently with to be able to find whether or not he did commit the offense.
For count 2, does property only apply to salary and benefits given to Cindy Blitzer, or can it include salary and benefits given to Tyler Henderson or others? The answer given to the jury, property, refers to benefits and pay given from the AOC to Cindy Blitzer. That's an interesting question.
Yeah, I find that interesting also, because whether it's given to one person or two people shouldn't necessarily make such a large difference. But it, again, may be at the different times one person was receiving a benefit, and then later we have a different person receiving it, and they're trying to piece together whether or not he did have the intention to commit these crimes, did he have the intention to kind of cover it up. So it could go to what his motive was as to whether or not he was giving certain people compensation or not.
And they're saying, let's just focus on Cindy here. Let's just focus. Maybe they were saying, look, we can't get him on Cindy, but maybe we can get him on something else, or maybe it's all together, maybe a few counts of it.
Yeah, it's hard to say, because Cindy wasn't charged with anything, which is
no, she was
large.
Not.
Now that's understandable, as many may think that what she did was horrible because she's taking money from the government, but it may not necessarily been her obligation to get work. It was Blasher's obligation to give her work.
But she did say on the stand, I knew what I was doing was wrong. And you say that on the stand, it doesn't get any more clear than that.
Well, but that, and her husband did the same thing. But that's easy to do when you're given a plea deal that, one, she wasn't charged with. And I'm assuming that was part of Craig's deal, is
right.
That don't charge my wife. Because he knew about the investigation 10 months before he even told her.
Right.
So there's obviously some kind of, he was trying to protect her because he gave up his law license in this plea deal. But it's very easy when you're given a deal that says you're not going to be charged, your wife's not going to be charged, and you won't go to jail as long as you testify against this other person.
Okay, final question that the jury asked was for count 1. Again, that's the false pretenses one. What is the, that's the conspiracy one. For count 1, what is the legal definition of conspiracy? Can you conspire for just letting things go on? For example, not being an active participant? They were told that an agreement may be verbal or implied by the actions of the party. What do you think the jury's thinking there?
Well, I think it goes back to that similar question they had about the representation. In order to find somebody's guilty of any criminal offense, there's usually going to be a mental state, something that was either they intended to do it or they negligently did it. So in order to conspire, there's going to be certain mental states as well as certain overt actions, I believe, that will be necessary to establish. And I think the jury's just trying to gather all that to figure out if it did or didn't actually occur.
California lawmakers taking up a bill that could make the state the first to mandate medication abortion as required health service at public universities by 2022. Is this a good idea or a slippery slope for college students? Here to discuss is our panel, Bernadette Tazy, campus reform correspondent and a student at California State University, radiologist Dr. Nicole Saphier, and Brad Micklin, a trial attorney. Thank you all for being here. Bernadette, let's start with you. Is this a good idea?
Thank you. Well, providing abortion on college campuses is not a good idea. This is not what universities are for. They should be focusing on educating students. The Leadership Institute's campusreform.org reports on examples of universities taking on politically charged issues. And this is another example of the California legislature inappropriately pushing their political agenda on university students. But not only that, starting in 2022, the bill purposefully leaves the door open for taxpayer dollars and for student fees to fully fund the entire program. And the UC and CSU systems are already estimating that the private donations that will be provided for the beginnings of this bill implementation would not be enough, and that student fees would likely be funding part of this bill.
Brad, Bernadette brings up a good point, and the question is this something schools should be doing versus focusing on the education of the students?
Well, I think the schools actually have the right to do that. The question is if they have the right or not. There's no way to deny that the right to choose is deeply woven in the fabric of our law and society, and this is just a logical extension of that.
Let's go ahead and take a look at a statement here that we have from California Democratic Senator Connie Leyva, the author of the bill, and it says, quote, "No woman makes this choice lightly, but when you need it, you need to have access." Dr. Nicole Saphier, for people who don't know, why don't you share a little bit of your story before we get into this?
So medical abortion should not be confused with the morning after pill or Plan B, which, by the way, is already available in vending machines all across campuses. morning after pill you essentially take after you have unprotected sex to decrease the risk of developing an unwanted pregnancy. Medical abortion is a two-step medication that you take after a pregnancy is confirmed to abort said pregnancy.
Right.
Now, my concerns are you take these two medications, you have to go, you have to get a prescription, you actually have to sign something saying that you're taking this and that you're going to be safe while taking it. And it causes you to abort whatever is produced. And then, unfortunately, there are some risks with it. However, they are rare in the first trimester if it's taken the right way and under medical supervision.
Right. For people who don't know, though, you got pregnant at a very young age.
Yes, I did.
Tell part of your story.
So, I, at the age of 17, became pregnant myself. I was in high school, and I did make the decision myself to have the baby. And, I was a single parent in my senior year of high school as well as college, and it was very difficult. There are a lot of people who, when they have a child in college, they do end up dropping out. Thankfully, I was not one of them, but people do that. So, now, I'm not going to get into the politics of it, but there already are abortion medications. There already are these services at college campuses. This is just another one. And although they're talking about public funding of it, from legally at this point, correct me if I'm wrong, it sounds like they still have to be using private funds for the abortion medication, whether you agree with it or not.
Is that right?
Yes, well, most of the funding issues that come into college campuses, especially private universities, would be considered private funding. And most of the federal funding, which may later becoming an issue with this kind of statute, is directed to the students themselves. There are billions of dollars that go to research and development grants to schools, but largely it's going to be private funding.
Okay. Let's go to Bernadette right now, and let's take a look at these numbers. 2.75 million women in the U.S. have used the drug since 2000. That's according to the manufacturer. Bernadette, it begs the question, if this is so easily accessible for girls, for women in college, does that take away a part of the decision-making on behalf of the woman, like your actions, right? You always have repercussions from your actions.
Right. Well, one thing I think that is very important to remember is that although the supporters of the bill say that they need more access to abortion, there is no lack of access to abortion in California. And there's an abortion pill provider within an average of about 6 miles of every CSU and UC campus, public university campus in California. And so I think this really speaks to the fact that this bill is truly unnecessary and that higher education should be focusing on academics.
Yeah. All right, Bernadette, Dr. Nicole, Brad Micklin, thank you for joining us. We'll certainly be following this and see what happens.
Thanks for having us.
So joining me on set is trial attorney Brad Micklin, and we're very happy to have him. Brad, it's great to have you here on the program for the first time.
Thanks, Jesse. I appreciate coming in. I love the show. Big fan.
Well, thank you for that. So let's talk about this case. There's a lot of moving parts in it. You have a Marine who was killed. You have a wife who was testifying against the defendants. And these guys, their defense attorneys have said systematically that the police made a mistake here, that they went with a narrow view, automatically said that our clients did this, when they're trying to say there's all this evidence that maybe they didn't. What do you think about it from a general perspective?
Well, I think it's interesting. As a defense attorney, you're always going to try to poke holes into the prosecution's case. But I think even more important than those points is the testimony from Megan herself, as you alluded to. If she were to get on the stand and say, you're the person that shot me in the leg, or you're the one that shot and killed my husband, I think that would have been the literal nail on her coffin. But she didn't say that. And what she did say was that she couldn't, or at least didn't want to, identify the assailants. And I think that's going to really, really play large into the defense position here.
These guys have distinguishing characteristics, including a face tattoo on Mr. Canada. The defense made a big point yesterday, poking that out, and during that police lineups, they actually covered it up. They covered it up because, according to the police, they couldn't find other people with face tattoos, and that wasn't an identifying feature that was described. So they actually covered it up because they said if they kept the face tattoo in a lineup where everybody else didn't have face tattoos, it would have suggested something to the victims who were trying to point them out. Does that make sense to you?
It's hard to say really at this point whether or not it makes sense. I think, again, as a defense attorney, you're going to do as much as you can to have as many different items to poke holes into. And I think alleging police misconduct is always going to be a popular theme. There's a lot of history in high-profile cases where that's been alleged, and it really plays into the hands of the jury.
These two men who are charged with the murder of this young Marine, Jonathan Price, as well as injuring his wife, Megan Price. Now, that is what I want to talk about right now. Megan Price, her 911 phone call was played for the jury. And this is not just any 911 phone call. This is the call she made right after the shooting and the robbery.
Well, I mean, it certainly brings the case home. I mean, you know, your heart goes out to Megan when you listen to this tape. But it offers, I think, very little for the case itself. I mean, there was a brief description of dreadlocks and the color of the assailants, but I think it was used more for the heart-wrenching aspect of it to really put the jurors in the moment of what was happening to her and her husband. And I think that's usually to play more on the emotions of the jury than the actual facts of the case.
Dreadlocks. Quincinio Canada had those dreadlocks. We show you his mugshot all the time on our network. That is a really strong distinguishing feature. Now, again, he was put in a lineup where there were other people with dreadlocks, but he was picked out. This seems like a very strong case against the defendants. Would you agree?
Well, it's hard to say. A lot of people would believe that the case is strong against them because of the identification both of Megan Price, but also the victims in the hotel incident a few days earlier. But at the same time, there was also mentioned in the defense opening statement that there's DNA evidence that was found that doesn't match either of the defendants. So it's going to be questionable how that actually gets introduced and whether or not that actually hurts or helps the identification issues.
Taking a step back, I keep forgetting, by the way, that this case has taken, what, 4 years to finally get to trial? That has been an issue of itself. Why has this case taken so long to finally get to trial there in Kentucky?
You know, it's hard to say. You know, as you know, we have a right to a speedy trial, but you also need to have a fair trial. So there's a lot of issues that are going to play into any type of litigation, especially a murder case like this. I mean, you have a long period of discovery where you have to get investigations and witness statements and exchange information. There's also always going to be a lot of pre-trial motions to exclude evidence or to bring in or out different people that will be testifying. And then I think lastly, after you get past all these hurdles, you have a lot of people's schedules. You know, we forget that the court system is really just made up of people. So you're always going to have, here you have several attorneys, you have a judge, you have several victims and families. I think coordinating all these people to get together to start a trial is also going to be a very large consideration.
I think the scheduling of the public defenders was a big issue because they had other cases lined up. The judge in this case, I believe her name is Judge Goodwine, was not happy about pushing this off and pushing this off and pushing this off. I think it was either last summer or last spring when she really got fed up at this. But here we are today. The trial is finally happening, and we are covering it here on Law and Crime. Any witness, including a person who was right there during the shooting, how do we judge if we're sitting in the jury? How do we judge everything that they saw and everything that they heard 4 years ago, especially when she was the person who got shot in the leg? So I imagine the defense would try to pick up on that, or at least put something in the minds of the jury that, you know, her recollection might not be everything you imagine.
Well, yeah, and there's mixed opinions about that when it comes to trial work, because some people think that your identification, your memory is poor when you're in a high stress environment, and others think that because your life is on the line, you actually have almost a photographic ability to remember everything. So it's hard to say, but let's not lose sight of what her actual testimony was, and that was that she can't, or at least she said doesn't want to or isn't able to name the defendant. So it's not a question of whether her recollection is accurate or not. There wasn't really a recollection that ties the defendants to that incident.
So in other words, what you're saying is it actually validates her in a way. Look, it's not like you said, she came and said, these are the guys who did it. She said, I didn't want to come out at first and make a mistake. So I think that adds credibility to her. That's what you're saying?
Yeah, I think absolutely. I mean, let's not lose sight of the fact that this is a death penalty case, and I'm sure that she's aware of that fact, because she didn't say that she's not able to identify them. The testimony sounded more like she didn't want to. She didn't want to make the wrong choice. So while we can't measure what her losses were in this incident, she's still going to be hard-pressed to say these people's lives should be taken when she can't be absolutely certain.
What do you think's going on in her mind as she's looking at them and saying the man in the white shirt, and she's looking at him and looking at him? What do you think's going on in her mind?
You know, it's really hard to be able to tell what's going on in the mind of a person who's been through such a tragedy. You know, this story does get more sympathetic. You know, here is a young couple, you know, good-looking, young, married. You know, he's a Marine. He's, you know, pledged his life to protecting our freedom. He's out celebrating her birthday. and loses his life by sort of defending her honor, trying to protect her. Even if I don't think it was $60, as you mentioned earlier, I think it was her safety that he was actually trying to protect, and he gave his life for that, which is what Marines do. So to speculate what's going on in her mind while she sits there, it's impossible for us to know.
It really is. And you think about it, we cover a lot of cases here on Law and Crime where there's a relationship between the defendants and the victims. Here, this is just, these two men really had no relation to the Prices at all. And, it seems like with these kinds of acts of violence, why did it happen? I keep asking myself, why did this happen? And it could be them, or as the defense are saying, that there's somebody else that might have been blamed. But whoever did this, it seems that it had no relation to the victims, which is eerie. I find that very eerie. What do you think?
Well, it is strange, and even more odd about this case, there are several different victims, several different incidences. You have the hotel incident where the gun was taken, then you have this murder, and then the alleged murder or crime spree that they committed after the murder. But part of me wonders if this is more the prosecution's attempt to link the defendants to this murder, to the gun. So you have to bring in the hotel incident, and then you have to bring in the murder weapon. So it's sort of like they're trying to put their pieces together in this puzzle. But that may actually seek to backfire for the prosecutor, because at the same time, you're leaving a lot of places for the defense to poke holes into the story. Now, I know there's already talk about whether or not the gun that was recovered was black or silver. There's questions about the person that they actually found the gun from.
Let me ask you about
wasn't even charged apparently in this incident.
Let me ask you about the gun. Why would they, if this is all true, why would they use a gun they stole from another robbery in this crime? Why? Doesn't that seem like, why do that? If they had guns during the robbery at the Quality Inn, why not use one of those weapons?
Well, I think you're trying to put some intelligence into people who probably didn't have a great level of intelligence. I mean, one way or another, these are violent criminals. If they're tied to any one of these incidences, even at the end, the man who had the gun was trying to sell it unlawfully to an undercover agent. So you can't really expect, rational, intelligent choices when you're looking at this kind of behavior.
Here's my question to you. This case, where the defense has said that this is about a matter of mistaken identity, right? They're saying that you have the wrong suspects here. The DNA evidence will exonerate my clients. There were, let's talk about the robbery that happened 6 days before this shooting that Megan just talked about. 3 people were held at gunpoint. They alleged that it was these 2 men, Quincinio Canada and Dawam Mulazam, the same men that are alleged to have shot Jonathan. But the testimony of these 3 people, I didn't feel 100% confident about it. So the defense first poked the hole in Mitchell Smith, who had a racist Facebook post. Then Jessica Hansford said that she couldn't 100% identify anyone from the photo lineup. And the only person that could identify somebody was, I think, Shane Hansford. I believe that's his name. Shane Hansford, who owned the gun that was allegedly used by these defendants in the Jonathan Price shooting. He was the only one who identified Mulazam from the shooting in the lineup. So you have one who might be tainted, one who wasn't sure, and then one who could only maybe identify one of the suspects. What do you think about that? These are 3 victims. Who better to know about who did this than them?
Yeah, I agree. I think it's very significant. I think identification is a huge issue, and probably right now the strongest point that the defendants have. That Facebook post goes not only to undermine the credibility of the testimony, aside from the racial aspect of it, but it completely undermines the identification, which is crucial. Which sort of brings us back to that Russian roulette point we were talking about with social media. Is that you're putting something on social media which was just a ignorant comment, and now it's going to undermine a capital murder trial. And that's why I think for instance, I tell all my clients, I say stay off of social media during your cases, because just no good comes from it.
And what do you think about this DNA evidence? The idea that the defense said, well, if you look under the fingernails of Jonathan Price, they don't match, that DNA doesn't match any of the defendants. What do you think about that?
Well, it's an interesting point. DNA, first from a jury standpoint, I think is always a significant issue, because it's very complex. And if you're looking to just create reasonable doubt, DNA is probably the easiest way when you're talking about a jury of lay people. But more importantly, it's interesting that they're even making it an issue, because I don't remember any testimony that there was a struggle.
Didn't she just say that? Didn't Megan just say there was some sort of scuffle, that there might have been an altercation between her husband and the 2 assailants?
I'm not really sure, and I don't know at this point who's now was the DNA and when it was found. So it's kind of convoluted at this point, and it may just be being introduced as a red herring just to create more doubt, or there could be something seriously that undermines the prosecution's case with the identity. You know, some people will say time heals all wounds, but this is one that I don't think time will. You know, aside from the tragic loss of her husband, she has a permanent injury, and it all happened, you know, on or around her birthday. So she's going to have this painful reminder every time that she moves, every time her birthday comes up, anytime her family's together. So I think, and we could hear it in the tape, I mean, that kind of trauma is just going to be relived, I think, over and over again by her.
You know, she said her left leg, where she was shot, is now shorter than her right leg, creates issues of balance and back pain. I mean, and as you said it so well, this happened on her birthday. It's going to be a constant reminder for her, and this is just a tragic case. Here's my question to you, and it's something that always been going in the back of my mind. He was shot, she was shot. These same men are alleged to have 6 days before engaged in a robbery. Why didn't they, and I'm happy no one else is injured in this case or anyone was killed, but if they showed their faces, and it's clear that they did, to the 3 victims at the Quality Inn, why didn't they take action against them? I mean, they showed their faces. Why didn't they shoot them?
Well, it's hard to say. I mean, either at the hotel, there's some question about how much the witnesses actually did get to see them, because I think they were told to lay down on their back. So, you know, their involvement from the assailants, I think when they saw them approaching, was more so than when they were actually in their presence. And you got to couple that with the fear and anxiety that's obviously going to race through your mind. But again, I think this is all part of the prosecution's case to try to tie all this evidence together. You know, they have Megan, who can't really give you a strong ID. You have the hotel victims who can't really give you a strong ID. So I think they're just saying, if you can have enough people give a little bit, when the jury puts it all together, maybe you'll have a strong identification for these defendants. Because otherwise, I think individually, it's not going to be enough.
Well, according to one of the victims from the Quality Inn, he heard, I believe it was Dewan Mulazim say to Quincinio Canada, "Come on, nephew." Now, that's a big statement to make, because how many uncle-nephew crime sprees do we have like this? I mean, that's a big identifier.
Yeah, I think that's going to be a really big point later because of the problems they're having with identification. You know, when I first heard that, it did seem strange, and it couldn't be coincidental that the 2 people that are in this crime are nephew and uncle, and that there's a reference or calling each other that. And given the problems that the prosecution's having with the identification, I think they're going to really try to hammer that part in their closing so that they can really tie all this little pieces of identification to something that's really meaningful for the jury.
I didn't want to be responsible for making the wrong choice in terms of that lineup. What did you think about that?
Well, I think that's the most crucial part of her testimony, because she's not saying, I can't identify them. She's not saying that I don't know if these are the people that attacked us and killed my husband. She's saying that I don't want to be responsible for the wrong choice. And, you know, given what she's gone through, you know, it's pretty remarkable. I mean, even, you know, when you listen to her 911 tape, you know, what's remarkable about that in and of itself is, in the very beginning, she's actually able to keep it all together when she's on the phone. You know, she can describe her injuries, she's describing what they look like, and, you know, she's almost calm. And I think it's at the point where maybe she actually started to see her husband on the ground as she started to really lose it. So, you know, she's got a really strong character, and I think it's that character that's keeping her from saying it's these 2 men with certainty and they should be put to death.
What an impossible position to put her in. It really is. It's a really, really tough position. In Kentucky, about a Marine who was allegedly just trying to protect his wife when a robbery fight went wrong. 2 men are charged with shooting and killing Jonathan Price and shooting his wife, Megan Price. She was shot in the leg. She survived and testified earlier in this case. And the 2 men, Quincinio Canada and Dewan Mulazim, are charged with Mr. Price's murder, and they could face the death penalty if convicted. What I want to do is play the testimony right now of Detective Timothy Upchurch from the Lexington Police. This was the lead investigator in this case, and he had a difficult job because he didn't just investigate the shooting of Jonathan Price, but he had to investigate this robbery at the Quality Inn that happened 6 days before. And evidence from that crime scene is being used to link the defendants to that robbery to this crime. And they are being charged in connection with both of those incidents. They face robbery, assault, and murder charges. So let's learn a little bit more from Detective Upchurch about what happened in the investigation. Okay, so that was Detective Timothy Upchurch explaining how he investigated this crime. And remember, he was the lead investigator in this case who was investigating a robbery at the Quality Inn and tied it to the shooting of Jonathan Price 6 days later because the same gun that was stolen at the robbery at the Quality Inn was allegedly used to shoot Jonathan Price. And it is believed that Quincinio Canada and Dewan Mulazam, the two defendants, are the ones that committed both of these crimes. I'm here with trial attorney Brad Micklin to discuss this a little bit more. Tough job for this guy to investigate both crimes. And how difficult is it in your experience when you have two separate incidents, you're charging the clients for both crimes 6 days apart and trying to tie them to both crimes, but really the way that they're tying them is with a weapon that didn't belong to them specifically. It was a weapon that was allegedly taken from one of the victims, used in another shooting, and was ultimately found in the hands of a third individual who's not one of the defendants.
Yeah, it's an interesting sort of puzzle that they're trying to put together. And I believe the one defendant who did have an opening statement alluded to the incentive that the police may have had because there were a lot of high-profile murders that I believe were unresolved. So there's claim that they were under pressure to actually resolve and to not quickly go to trial because it was some time. But there's a question of whether or not the investigation, which could be argued to be very convenient, that they were able to get all these different pieces together, or it could just be that that's his job. He investigates crime, and one crime will often lead you to another. I mean, it's hard to believe a person involved in such a violent crime that this would be their first initial offense, so it's not unusual that you might find subsequent or similar actions and crimes by the same people.
So the shell casing that was found at the Jonathan Price crime scene actually was the one that was when Shane Hansford, it was his gun at the robbery. They asked him to get a shell casing because he had fired that weapon before. They matched it together, and that's how they found it. But now let's talk about how they actually got the two defendants. And it was through a lineup. So the three victims in the robbery at the Quality Inn were asked to look at a lineup of these two individuals. One was a six-pack lineup. That's when you have six individuals in a frame and you pick it out. And then there's a sequential lineup where there's one photo after another. Shane Hansford picked Mulazam from a six-pack, while Smith picked Canada and another man from a sequential lineup. The other man obviously couldn't have done it because he was in, I don't say obviously, the other man couldn't have done it because he was actually incarcerated at the time. But then we learned that Mr. Smith, Mitchell Smith, who picked Canada out, he did a Facebook post that was extremely racist and said that all black people look the same. So how can you, and Mr. Upchurch was grilled under cross-examination, how can you say this is a reliable lineup if he thinks all black people look the same? And then the third individual, Jessica Hansford, couldn't even identify anybody in the lineups. We talked about it earlier. This seems to raise a little bit of questions.
And I agree, Jesse. I think the lineup and identification issues is going to be very, very compelling in resolving this case, whether it's favorable to the prosecution or to the defendants. And there's always going to be problems with lineups because it's not just the procedure that's being followed, but it's usually, you're almost always going to have defense attorney there to watch the lineup. And they're looking for not just who was identified, but what questions were asked. You know, how long did it take them? How certain did they really seem when they made these identifications? And when you hear things like this post, aside again from the racial aspect of it, that suggests that he doesn't know what the lineup was or who was the offender. It's going to really create a lot of challenges, I think, for the prosecution to convince the jury that these lineups and these identifications are credible. Well,
let's learn a little bit how these lineups were created. We have Detective Timothy Upchurch from the Lexington Police. We watched him on the stand. He's about to go into, this is his prior testimony from yesterday, about how these lineups are created. Let's learn. That's Detective Timothy Upchurch from the Lexington Police testifying in this Marine killing case out of Kentucky. And now I want to talk about lineups because that is a big issue in this case. The defense counsel for Quincinio Canada and Dewan Mulazam, the two men who were charged with shooting this Marine, Jonathan Price, they made the point that these lineups were kind of biased and there was problems in the way that they were presented to the victims. Well, were they? Was there an actual bias? Let's learn a little bit more about them with Brad Micklin, trial attorney. So I want to ask you a couple of questions about this. The first part about this, Mr. Upchurch said that typically he doesn't record photo lineups, and he also didn't feel that he needed to because he had another detective who was present. He said he doesn't really record them because he doesn't want to make the victims feel uncomfortable. What do you think about that?
It's kind of a strange practice. I think given the nature of an investigation, and if there really were a lot of high-profile cases that were either resolved recently or unresolved recently, the fact that they're not going to record something that is so crucial to their case suggests almost that they may not want it to be recorded, that they might be concerned about inconsistent information and that the defendant's actually getting that. Like I referenced earlier, if it takes a long time for them to answer, or they ask questions, or they use vocabulary that suggests that maybe they're not certain, that would all be recorded and then played to the jury or even put into the defense closing argument. So I think the fact that he doesn't tape it could be problematic for them.
And is there any difference in your opinion about, okay, we're going to have individuals in a six-pack lineup where you see the 6 photos, pick someone out from there, as opposed to a sequential lineup where I'm looking through the photos. Do you think there's any difference there, and why separate the two? I mean, again, I just want to make sure I get this right, that Shane Hansford picked Mulazim from a 6-pack, while Smith picked Canada from a sequential lineup. Why have the 2 different kinds of lineups?
I'm not really sure why, but I know it's sort of going to be problematic depending on which one they're utilizing, because if you have the 6-pack and you have everybody there, I think the identification is a lot more powerful, because if you're going picture by picture and you're the person that you're about to make the identification, I think if you don't get through all the pictures, you might actually jump the gun and make the wrong identification. So I think that maybe prosecutors or the investigators have their own preference, but I think the 6-pack is going to be much more effective.
Let's talk a little bit more about that Russian roulette story. Brad, my question to you is, why were they charged with murder? I mean, they said it's a modified version of Russian roulette, but I'm imagining if Russian roulette went bad, murder wouldn't be the charge. What am I missing here? Well,
I think there's a couple issues that are going on here, and it's going to turn and develop as the story continues, because I think we're just at the early stages of it. But the story seems to be that the defendants are at least claiming that it was Russian roulette and that the victim himself may have actually pulled the trigger. While that may be true, and that would certainly limit or reduce their culpability, but at the same time, even if that were the case, if they were involved in this incident or they brought the gun, their intent may actually transfer over into a different crime or into murder, even though they may not have actually intended to kill him.
But is there evidence that they wanted him dead? I mean, I read a little bit about this story, and it seems that they might have had a grudge against him, and might have been something going on that we don't know about yet. Have you read about that?
Well, there's a few things that are in the news right now, and the main thing that I've heard about is a social media post from one of the alleged defendants, where there's a question that maybe he admitted to this crime and maybe there was some motive. But the problem with social media is, although it's been with us for a long time, its use in the courtroom is relatively new. So there's always questions surrounding authenticity, admissibility, and then also just credibility. You know, how many times have you seen a Facebook post from somebody saying something about how great their life is, but then you get to know the person's really not that case? So the mere fact that they posted something that may have suggested their involvement doesn't necessarily mean that it's accurate.
In these kinds of cases where people victims take a role in a very dangerous activity, is there any defense that they assume the risk of what's going to happen? Again, we don't know all the details of what's happening in this case yet, but if they were involved in consensual Russian roulette, which I can't believe I'm saying, and ironically this happened in Las Vegas, I mean, this is not the kind of gambling I think anybody wanted, but again, is that a way that the defense could say, look, he assumed the risk?
You're meaning the victim?
Meaning the victim.
Well, I mean, to some extent, certainly. If you are engaged in a dangerous activity like that, or even playing with a loaded gun in any way, you're certainly assuming some of the risk. That doesn't necessarily negate the fact that the other 2 individuals who were involved didn't cause or create a dangerous situation that led to his death.
Weird part about it is I hear that, again, one of the victims, one of the defendants allegedly shot him point blank in the face. How is that a modified version of Russian roulette? My understanding was that the victim will always pick the gun up and put it to his head or to his face and pull the trigger. I guess that's where things get a little weird for the defendants.
Well, and it's going to be a troubling defense because, you know, we know what Russian roulette is supposed to suggest, but we don't really know what happened here yet. So it's going to be really important to find out how he died, where the gun came from, whose fingerprints are on there. I think once these pieces start to come together through the testimony and in the media, then we'll have a better sense of where the case is going to go.
A 17-year-old and a 16-year-old are both charged as adults. What's going on?
Well, I think it's sending a serious message. The juvenile system is about rehabilitation.
And Brad, let me sorry to interrupt. Brad Micklin, I messed that up.
Yeah,
See, your first time on the program, and I keep messing it up. Brad Micklin.
I let it go because I want you to invite me back. So.
My apologies.
That's okay.
Please continue.
So like I was saying, the juvenile system is about rehabilitation. So the punishment is always going to be significantly less, especially there's never any death penalty. I think when you have children, if close to the age of majority, the legal age, and you have a heinous crime like this, I think that they want to have more severe punishment so it deters other people from committing these kinds of acts. But I also think there's an issue about the actions of these kids and the lack of either responsibility or accountability. And I think, the story that I heard was after this, they were either posting on social media and they were either in a stolen car or at least driving recklessly, which shows almost an indifference to what they had just done, whether it was intentional or not. And I think that played a part in the decision to try them as an adult.
And what could ultimately happen to them if they are found guilty of this?
Well, it's hard to say because I'm not really sure about Vegas's laws about death penalties and things like that, but the punishment is going to be the same as it would be for an adult.
Now, here's the weird part about it. We talked about it in the preview, in the report from Anthony, that it was a modified version of Russian roulette. Now, I don't know what that means, but if he was shot in the face by one of these guys, that's not the Russian roulette that I have always heard of. It was always my understanding that the victim in this case, and when I heard Russian roulette, I assumed when I first read about it, he took the gun, put it to his head, and it was an accident of some sort. That doesn't appear to be Russian roulette.
Yeah, I would agree. I actually noticed it in the clip earlier. I originally thought that the use of the term Russian roulette was really just to kind of put a spin onto it. It's in the media. But when they say modified, it suggests that there was something that happened, and we're not really sure who pulled the trigger, and that may be why it's modified, or, I'm not really sure how Russian roulette's really played, but I understand that typically there would be one bullet and then it's randomness, so there could be that the gun was full of bullets. It could be almost anything. We just don't know at this point.
The mother of this Mr. Minkler said that Caruso, one of the defendants, had a beef with him, and that this really wasn't an accident of some kind, and perhaps that's why the Russian roulette theory came forward. So it adds a little bit of gray to here. But if there was really a situation, and the details are still coming forward, where a modified version would be, okay, we spin it, and then I point the gun at you, pull the trigger, point at me, is there any way this could be defended as an accident?
Well, it could be defended as an accident. It's not necessarily going to negate the gravity of what they did.
Because I'm assuming then that they would say, look, the victim assumed the risk here. The victim assumed the risk.
And that's possible. It's very hard as a defense attorney to make the victim the cause and to blame the victim in a trial before a jury. So you kind of have to tread lightly there, but I'm sure they're going to try to do something to at least remove the blame from the two kids that were involved and try to place it as sort of gently as they can onto the victim himself.
We're learning new details about this. First up, it says that they never called 911. Detectives reportedly found F-mat spray painted on the closet door where Minkler's body was found. Minkler's wallet was found in the stolen car that Mr. Harlan was allegedly driving, and he drove in a police car chase. They eventually caught up to him, and Minkler's wallet was in there. It's as you heard in that short report from Anthony, that Harlan allegedly said that he wanted to clean up the crime scene, or that he helped clean up the crime scene. And when they looked at Caruso's cell phone, one of the defendants, it said, bro, I just caught a body. It was a video of him saying that. And finally, the last piece of information that we just learned was that Mr. Caruso, again, one of the defendants, never allowed the other participants to handle the firearm or pull the trigger themselves. What do you think about these developments?
Well, I think some of these issues go back to your earlier question about why are they being tried as adults. There's always a chance when you have guns involved that things can go horribly wrong. It doesn't necessarily mean that was the intention. It could have just been foolish and went tragic. But what you do after that says a lot about whether or not it was an accident or was it intentional. If you accidentally harm somebody and then you call 911 to get that person help, well, then you're at least acting consistently. If you cover it up or hide it or brag about it, that suggests that it may not have been an accident.
But the revelation that if this is true, that he never allowed them to handle the gun, the defendant, never allowed other people to handle the gun, how on earth is this Russian roulette? How can you blame it on Russian roulette?
Well, we're not getting the statement from the victim. We're getting this from the people either that are on trial or the people that are representing them. I think there's going to be a lot about these I hate to call them children, the two defendants, I think we're going to learn a lot about them in their past. We don't know anything about these kids, what they were like before this, what possible trouble they had before this. May not even been the first time that they committed an act like this.
Investigators say that Caruso, again, one of the defendants, broke down and admitted to being involved. He said, though, it was an accident and that he'd been using Xanax. What do you think about that?
It's hard to comment. I mean, I don't really know the exact effect that the Xanax can have, and I don't know how much he claimed to have been using. But I don't know if that's going to be enough to negate his involvement. I don't know if it's going to be enough to say that what they did was tragic because he was under the influence. You still have, if you could commit these acts and you could take the steps to cover them up so carefully and methodically, then it's unlikely that the drugs or alcohol or any kind of substance he had actually affected his abilities.
Well, the mother in this case, Jamie Shanklin, who's the mother of this young boy, the 17-year-old who was killed, she said she believes that Caruso had a beef with her son. She doesn't believe it's an accident. She said, "My baby never came home. I've been mourning for days, and now I feel my anger." It's a really tragic case. We're going to keep covering it. As soon as we have an update about it, we'll make sure to let you know. But before we go back into our next case, I want to sign off Brad Micklin. Brad, it was great having you on the program. First appearance. Can't wait to have you back.
I'm looking forward to it, Jesse. Thanks.
Thank you.
Let's bring in trial attorney Brad Micklin. And Brad, I think it's probably fair to say this probably won't have political fallout for the president, given his supporters voted for him knowing he's not a saint. But what could the legal fallout be for the president?
Well, it's difficult to say because it's just coming out now. And my understanding of some of the research and comments is that there are other tapes that are going to follow. So I think as they come out and develop, we'll get more information. But there's also been issues about campaign financing and issues that may be involved with these alleged payoffs that I think could become either civil penalties, once in a while, even criminal penalties.
And criminal penalties because of not only campaign finance laws, but if Cohen is suggesting that he perhaps misrepresented to a bank when he got a loan to help pay this off. If he was misrepresenting what this was for, and he can now say, oh, and by the way, I told this guy, Donald Trump, what it was really for, then there's a conspiracy that could be alleged involving Donald Trump.
Could be. I'm not sure. I haven't heard much about the conspiracy, so it's an interesting point. I know there is big questions about anything of value being exchanged, whether it was by Cohen on Trump's behalf or from Trump back to Cohen. So I think as we find out what these payments were or were not for, whether they were to foster the campaign or whether they were personal payments, I think is going to determine whether or not there's a conspiracy.
But I guess to my question, apparently Cohen got a home equity loan or home mortgage loan that he used as collateral to help pay off Stormy Daniels, for example. If he misrepresented on a bank form what the money was for, that's a pretty clear, cut and dry case of making false statements or wire fraud.
Well, it could be, but the question is going to be what was the motive and whether was he put up to this by then running President Trump, or did he do it on his own fruition? I think it's going to be interesting because I don't think that there's going to be a direct tie between the president and Cohen. And the problem I have with it is because in the tape, he obviously knows he's recording, and President Trump doesn't. So you have to give some credibility questions to the statements he's making in all the statements and in all the tapes that they may produce.
From a lawyer's point of view, when you're making a case, wouldn't you put out the most damning evidence at the beginning? Does that lead you to believe that this might be the most damning tape he has, even though a lot of it is inaudible?
It's hard to say. I'm not sure why he would release this now. First, there's a question of whether he should have released it at all. I mean, everybody is entitled to confidentiality protection when they meet with their attorneys. And he didn't advise President Trump that he was recording this. So there's very little reason why he would have had to produce it in the first place. Only a few exceptions to confidentiality in the first place. And they have probably since long passed. So I'm not even sure why he released this one now.
Is it possible this is a squeeze play by Lanny Davis? In other words, Lanny Davis, I'm sure, is driving the U.S. attorneys here in New York who are handling the Michael Cohen stuff. He's driving them crazy by putting this out in the public domain. But he might also be making the argument, hey, I have valuable things. My client deserves a better deal than maybe what you, the U.S. Attorney's Office, is offering him in exchange for his cooperation on issues like Donald Trump.
I would agree. I thought when I heard this, I hate for the pun to come out, but I thought they were trumped up allegations. And Cohen obviously has a lot of incentive for releasing this at this time. And if he has others that he hasn't released, the question is why hasn't he released them? What is he looking for? Because it's clear he's damaged his relationship with Trump, so there's no presidential pardon down the line for him. So we now have to look to what is he trying to gain for his own side.
Let's go back to attorney-client privilege. What happens when someone's lawyer is no longer on their side, possibly on the opposite side? Do they lose attorney-client privilege?
Usually not. There are very limited exceptions to attorney-client privilege. Most states in New York, I believe, have similar ones to Jersey. And you can breach confidentiality if there's serious bodily injury that's going to occur to somebody, if there's a crime that's going to be committed, and that's sort of the spin that they put onto this. But I didn't see anything that would suggest any of those exceptions apply, especially since the conversation happened so long ago. It's only being released now. So it couldn't have been releasing it to protect any victim or to prevent any crime.
What are the consequences of breaching attorney-client privilege?
Well, there could be ethical consequences. You know, there are obviously the laws that protect all of us, and there's ethical rules that protect and govern what attorneys can do. There's possible sanctions. It could be suspended. It could be disbarred. Depends on what the rules say about when he can release and why he did actually release it.
But that would require a motion by Donald Trump to claim that he has somehow been injured by all this. There seems like there's every indication that Michael Cohen is cooperating with federal prosecutors, and the federal prosecutors have at least been satisfied that Michael Cohen is providing them with information that satisfies the criminal exemption to attorney-client privilege.
Right, but my understanding is that they've already seized all the tapes from his office. This was released, I believe, by him or his agents. So that's why I have a question about his motive to release it at this point. Can't possibly be to protect against a crime. If anything, I think it's just to protect himself.
I think that's absolutely right. I think what Cohen and Lanny Davis are doing here is they're trying to increase his value to not just to the prosecutors. We still don't know what the deal is for his cooperation or what the terms are. Maybe they've got Michael Cohen on something serious and he's saying, look, charge me or I'll accept something to something minor, and here's why you need to give me a deal because I'm so valuable and all this other stuff.
Or this may backfire and it won't help him.
Right.
Brad Micklin, thanks so much. Thanks for helping us understand that.
In studio with me is Brad Micklin. Brad, this is a little strange. You got 40 potential witnesses. You're looking at a manslaughter case. You're trying to say it was self-defense, and you only call 2 witnesses. What do you make of that?
It was shocking to learn that. I actually didn't believe it at first when they told me that because, again, there was 40 witnesses. If you listen to the defendant's opening statement, the counsel goes through a ton of people that he's planning to call, all these people that were involved in the fight. There was a toxicology report that says that there was PCP in the victim's bloodstream, and apparently none of that came out. I'm assuming that maybe the prosecutor just missed a significant element and the defense decided just to go on that and not to push opening the door.
Yeah, I was thrown on the fact that they only called these 2 witnesses. We are actually going to go to a quick break here, but again, okay, we're still watching live the defense closing arguments in the Demetrius Elder case. A lot of moving parts. Still here in the studio with me, Brad Micklin. Brad, a lot going on here. You got this fight, you got weed, you got alcohol, you got PCP, but I want to touch on something. The defense, actually, one of the key witnesses in this case was a friend of the victim, Corey McMath. You heard him just say something about Corey being a convicted felon. What does that have to do with anything other than trying to discredit him as a witness?
I don't think it has anything to do with it. I'm actually surprised that it was found to be relevant whatsoever. But we have to assume this issue was raised pre-trial, and normally you would exclude evidence that's not relevant. So there had to be some showing that it would tie into it. Now, I know from the defense opening argument, at least, that they were trying to allege that Corey sort of instrumental in creating this, that he brought Muhammad in for the purpose of this fight. So maybe they were trying to tie together the kind of person that Corey is, having this violent past, and is more likely to have done something like this.
Yeah, and that very well could be. And you and I were talking while we were listening to this closing argument here. There's a chance, in my opinion, that maybe Demetrius does walk on this because there was just so much going on. It would be different if it was just a road rage incident and the horn blew, he got out, the fight occurred, and then there was a stabbing, but you had this party, you had this fight, you had alcohol, you had drugs. What do you think?
I agree. I mean, I don't think there was much testimony from the opening statements through the closing statements that really tied Demetrius to a weapon and to the fight.
Right.
And I think what might be really interesting now is Armando, I believe, gets tried next. And he's probably going to be able to say, it was Demetrius, it wasn't me.
Right, and maybe that's why they didn't call him as a witness. And you made a very good point there. Like, there's just so much going on, but we've heard several testimonies that said Demetrius was not even there when this whole thing started.
Right.
So it goes back to this whole manslaughter charge. He wasn't there.
Well, I think he was in the car. I mean, both the prosecutor's opening statement and the defendant's opening statement put him in the car, but neither of them seemed to tie him to, like I said a moment ago, to the weapon or to the fight. So it was really unclear.
Or to the fight. That's what I meant. He wasn't there during the fight.
Really
and then, again, like we heard Corey say, Muhammad wasn't a violent guy, and I wouldn't allow that at my house. Just so many moving parts to this case. Okay, still hearing closing arguments from the defense in the Demetrius Elder case. And he's been up for about 20 minutes now, still in studio with me, Brad Micklin. Brad, you and I were talking, and the prosecution actually finished her closing statements in about 5 minutes. The defense has been up for quite a while now. Why do you think she was so quick in her closing argument?
My thought is that she's just not that good of a prosecutor. If you look at her opening argument, it was about 7 minutes long. I've argued motions that are 10 times that. And the defense opening argument was nearly twice that. But also, I think she might be trying to keep it closed because she has a death on her hands. She has some eyewitnesses. So maybe she's just trying to keep it more compact so that there's not reasons to argue reasonable doubt. I can't really tell yet.
Yeah, but she also can do a rebuttal once the defense finishes their closing arguments, correct?
Could be. I think some judges do and some don't. So we'd have to see what this one's going to do.
Yeah, now, with that rebuttal, I think she should have gotten everything she wanted to say out ahead of time versus waiting on this rebuttal because, to a juror that's going to say, well, why didn't you say that the first time? Why are you just now coming back? Were you not prepared? To your point, is she not that great of a prosecutor?
Well, if she knows that she's going to have this rebuttal, that may be different because I would certainly want to be the last thing that they hear before deliberating. So whatever points she has to make, whatever smoking guns she has, no pun intended, but she might be keeping that in her back pocket. So if she knows that she's going to close or rebuttal, then she's going to save that for that.
Yeah, and I think the defense is doing a really great job bringing out a lot of points and a lot of questions to make people have that reasonable doubt that they need to have in this case. Again, this is a manslaughter case in the state of Florida. Demetrius Elder is on trial right now.
This is an interesting case. The jury really has a lot of factual calls to make here. That's what juries are for. And this case has got a lot of he said, she said, a lot of conflicting facts that jurors are going to have to resolve. Brad Micklin is an attorney. He's here with us. Brad, good to see you. I appreciate you being on. So what do you make of this? This is a lot of factual back and forth for the jury to really dive into here.
Well, I think part of what's going on sort of both sides, obviously we have a prosecutor who's trying to prove manslaughter, which isn't the highest of burden, but we have obviously a defendant who's looking to prove reasonable doubt. And I think that's what we heard more about because the prosecutor's rebuttal sounded more like she was on the defensive as opposed to trying to establish the act that led to the manslaughter. So when you look at the defendant's case where we have Muhammad on a combination of drugs, one I believe being PCP, and all these other people, Corey and Demetrius, and this alleged history of the fights and the revenge, as they so called it, I think you're really creating a lot of potential reasonable doubt. And I think that's what the prosecutor was trying to work against in the rebuttal, as opposed to just establishing the manslaughter.
Yeah, it's interesting. And a lot of people are like, well, this isn't a long, drawn-out closing argument. We often see them. But manslaughter doesn't have a lot of elements in Florida. They don't have to prove premeditation the way they would in a first-degree murder case in Florida. Or they wouldn't have to prove in Florida on a first-degree murder that it was a murder that happened which was attached to some other underlying crime. Okay, so the burden for the state here is a lot lower than it would be in a lot of the other types of crimes that we follow. Could that account for the comparative brevity, I guess you could say, of the closing arguments here?
I think so. I was on a moment ago with Vincent before you signed on, and he and I were talking about that. I'm not a big fan of the prosecutor, at least how she handled a lot of parts of this case. But I think, I don't know if it was her decision or the office itself, but I think the not charging murder and charging manslaughter was actually a brilliant choice, because the whole, this is a revenge fight that the defense was bringing up, they could have flipped it and used the same type of argument that this was a revenge killing and gone for murder. And I think that would have been a hard charge to sell to a jury given this convoluted fact pattern. So I think the manslaughter made a lot of sense.
Yeah, exactly. Who did what, when, why? What was going on at this party? Was the victim, who went by the nickname Mohammed, was he there to settle a dispute? Was there something going on? You know, and in whose mind are we looking? Are we looking into the defendant's mind? Are we looking at the stereotypical reasonable person standard? Would a reasonable person have felt threatened by this action? You know, this is late. This is a stop sign. Why somebody who was at a party, who allegedly was there to settle a dispute, suddenly coming for me? The defendant might have been wigged out in that situation. You know, is it reasonable? A lot for the jury to really dig into here. Welcome back, everybody. We are talking about the case wrapping up today in the Demetrius Elder manslaughter case out of Florida. Jurors got the case about 10 minutes ago. We're waiting to see how quickly they may or may not come back with a verdict. So, Brad Micklin is an attorney. He's here with us on the Law and Crime Network. Breaking this down a little bit, we've got a lot of different factions of people testifying, and what we listened to right before the break was a friend of the victim, and he's saying, oh, no animosity, there wasn't anything bad going on, but I would expect when there was cross-examination of him that he would have been impeached because he was a friend of the victim. He's probably not going to get up there and say the victim is an aggressor.
Right, well, that's one of the pieces that didn't make a lot of sense to me. Aside from, and I know I commented before about the prosecutor, and I've never been a prosecutor, and I understand it's a challenge deciding who to charge, what to charge, when not to charge.
And you don't get to pick your witnesses. Right. That's the other struggle.
But here we had a witness that apparently was brought in by the prosecutor. I had two issues with the testimony. First was, if you listen to her examination, most of it was open-ended questions. Yes or no's, or I mean closed questions, like leading questions, yes or no's, where it's supposed to be open, who, what, where, why, when, and how. And she's leading the witness as opposed to examining and walking them through the testimony, but the defense didn't say a thing. So they let it go, but then the testimony itself almost seemed like she was trying to negate what the defense was going to be bringing out, that this was a revenge killing, where her job is just to establish that there was death. So I didn't even understand why she would call this witness as her own.
Well, you know, you get into a lot of sort of funky procedural things in Florida, because I did read some of the pretrial documents in this one. This case happened before the current incarnation of Florida's Stand Your Ground law. And there's a lot of litigation in Florida about it, just exactly how far back that new law can be used as a shield by a defendant in court, sort of retroactively, because there's an incident, then the law changed, and then trials happen. So it's like, is it a procedural rule or is it a substantive rule? And there was a lot of back and forth about that. So some of the jockeying I think we were seeing was a result of that. You know, once the defendant says, Florida, stand your ground, it puts the prosecutor on, you know, if not an additional legal burden, then certainly an additional edge to try to override that claim by the defendant. And we watched that play out in closing arguments. I think that some of that was what we may have been watching.
Yeah, that might have been, because most of the reviews that I've heard about this case did characterize it as a stand your ground case. And I know it's very controversial in Florida, so I thought that's what the defense was going to be bringing out. And then again, all we keep hearing from the defense is that it was a revenge killing. So I was kind of confused at what the actual theory was when you listen to the opening arguments, where they're supposed to be sort of mapping out not only the land of the testimony, but what the theory of the case is going to be. You didn't really hear this stand your ground claim come up at all.
So it was interesting. That's cross-examination. We heard more open-ended questions on the cross than we did on the direct. It seems like the defense wants to just let him tell a story, because he's talking about drugs that they were taking, and he was sort of digging his own grave from the witness stand.
Yeah, that's how I heard it too. I mean, he first appeared when he was testifying for the prosecutor. It was very credible, even though he was being led to his answers, because it was a fleeting answer, but he admitted to smoking marijuana. So to some extent, while that might not be the best thing to admit, at least he's credible. He's not hiding behind a different type of story.
He's not lying about it, but, you know, does that affect his perception of the events that he's testifying to? He's saying, you know, oh, the victim is peaceful, this, that, and the other thing. Well, if he's high on marijuana, does he really know what's going on?
Well, and I still have trouble seeing the relevance of this in the first place. He wasn't there. He testified he didn't even see it. the altercation happened down the street, if not further. So other than this revenge killing that the defense is trying to bring out, which I don't even know if they need to establish at this point, I didn't see the point of even calling this witness from the prosecutor's standpoint.
Testimony from the victim's girlfriend about how this fight broke out in her version of the events here. So we've got a couple different versions of events here that jurors are going to have to try to weed through. Brad Micklin is still here with me. Brad, what do you make of this? Is she credible? Is she covering for the victim? How should jurors take this?
There's a lot of layers to a witness like this because we have to acknowledge that she's a victim herself. I don't know how long-standing her relationship was, but she's certainly a victim. But that also gives her some incentive to see things differently. I'm not suggesting that she's going to lie or change the facts, but her perception is certainly going to have a different perspective because she wants to vindicate her boyfriend's life. And I can't see that as causing her to be consistent with what maybe other eyewitnesses might have seen.
You know, one thing that strikes me in listening to her version of the events is she's saying it's not so much the defendant as it was the other person who, you know, could be described as an alleged accomplice here, because the defendant and another person were in one vehicle, and then it was the girlfriend and the victim in another vehicle. It sounds like the first punch, if we're to listen to and believe her version of things, wasn't this defendant.
Right, and that's the problem I've had with this case since the opening statements is that I haven't heard either side, the prosecutor or the defense, actually tie Elders to the stabbing or even to the weapon. So this whole road rage issue or revenge killing, whichever one it was, doesn't necessarily involve Elders, at least at this point that we're hearing.
Is this a situation where Elder is going to be able to say, hey, look, these two start going at it, it spills over into me as that girlfriend just testified, and then at that point, everybody's throwing punches, and at that point, I have to defend myself?
That could be, but obviously I don't believe he testified, which I think was a good choice because you don't want to take the stand as a defendant in a manslaughter case unless you absolutely need to, and as a defense attorney, it's rare that you're going to do that. So while he could have, it's smart that he didn't.
Brad Micklin is still here with us on the Law and Crime Network. And Brad, look, here we've got some testimony from a police officer saying that the aggressor here, according to the victim's girlfriend, really didn't have any kind of wounds on himself. So does this lend credibility to that girlfriend whose testimony we listened to a little while ago, where she says this basically was her boyfriend who was bearing the brunt of the injuries here? It wasn't the person she says was the aggressor.
Yeah, I think it scores several points that the prosecution wants to make. I think, first, the officer identifying the solo cup does sort of set the tone that he got out and maybe he was going to shake his hand. He didn't have a weapon in his hand. But also, there was testimony that they had to find the car and that there wasn't any marks on this. And I think that's going to open up a claim that they fled the scene because they knew they did something wrong.
Yeah, this is an interesting piece of testimony to plug into what we heard earlier. But look, how long ago was this fight from the point that they served the warrant and then tried to examine this guy? Is that? I'm sure that it's been discussed. I just must be missing it in here somewhere.
Well, I think that's going to be either something that comes later or something that we hear with cross-examination. I think the defense counsel is going to be charged with also showing what the police officer didn't see or isn't qualified to determine. He's not a medical officer or medical educated in any way to know whether there would be a bruising and how long it takes for that to surface. And things like that, I think, are going to be subject to the cross-examination.
Jurors have a lot of facts to try to reconcile, and what they asked for was a transcript of testimony from Wendy Gimbolis, who we were just listening to, the girlfriend of the victim, and they wanted a transcript of the defendant's own testimony from a stand your ground hearing. They are trying to reconcile whose version of this attack at the stop sign makes the most factual sense. The judge said, look, you can get a playback of the video, but there is no transcript and evidence, and you can get a readback of Wendy Gimbolis' testimony. He said it might take a while, so this might push into next week from a timeline standpoint. But look, two different versions of what went down there, the defendant's and the victim's girlfriend. Who should the jury believe? And of course, we don't know the answer, but it's the rhetorical question. They're trying to reconcile that testimony.
Well, that's the jury's job. So when they ask to see something, you would hope that they would be able to get it, especially in a typed form, so there wouldn't be any question interpretation or recollection. Now, I believe this is more of a technicality where the judge said you can watch it. You can't read the transcript because we didn't move it into evidence, but having to watch it means you have to watch all of it or at least large portions of it.
Yeah, I mean, look, but I think the jury's doing what the jury is supposed to do. And ironically, of course, they're asking for pretty much the same exact stuff that we were playing back earlier today, trying to reconcile the facts from the two people who were there at the scene. That's exactly what they're trying to do. They want to hear from the defendant. They want to hear from the other person who was there. Jurors in the Demetrius Elder manslaughter case basically asked for some of that exact testimony to be played back. That's part of his version of what led up to this stabbing at a stop sign after a group of people, the victim and the defendants, were at a party. Jurors are trying to reconcile that with testimony from the victim's girlfriend that does not line up with that testimony. So Brad Micklin, this is the whole reason we have juries. They have to reconcile who's telling the truth and who's not.
Right. I mean, and both sides of this case had some strange aspects to the story that left me with questions. You know, and when you're looking to the defendant taking the stand your ground defense, they were the car in the front. They were at a stop sign. The question, why didn't they just go? You know, their refusal to move seems to what brought this about. So that is what drives weird about their whole position. But yet the defendant's position is I got out holding a Solo cup and went to shake his hand. That doesn't make sense either. So I can understand why the jury is going to have trouble reconciling both of these stories.
Yeah, exactly. You know, and I thought, if I'm remembering my facts correctly, didn't the car behind sort of pull up and then beep, and then, you know, so it's like, what did the person in the front car, if we're to believe the defendant, did he think that somebody back there was trying to get his attention for some reason? And if this theory that there was some animosity brewing at this party, if that was correct, maybe he was on edge. Right. Instantly because of the beep. He knew what was going on. Well, we're going to wrap up the broadcast today in just a minute. Brad Micklin, we appreciate you being here. It's
Thanks
great
for
to have
having
your
me,
analysis.
But right now, let's talk about one of our main trials, and let's specifically talk about the Carl Wimpy Jr. case. And here to help me break down what's been happening and what we can expect, I have a very special guest who's joining us in studio, trial attorney Brad Micklin. Brad, great to see you back here on the program.
Great to see you too, Jesse. Thanks for having me.
So let's break down what's happening here. He's facing felonious assault, murder, and now maybe voluntary manslaughter. Based upon what we've seen from the defense and the prosecution, do you think he could be found guilty of any of those charges?
I think he can definitely be found guilty of the felonious assault. It's just an assault during an unlawful act, which clearly this was. The murder and voluntary manslaughter is more challenging. I mean, it's unfortunate that there's a death here, but it's a barroom brawl. And even though they talk about how intent isn't necessarily required, you can't fault a person for possibly defending himself, which is another claim, because something tragic resulted from it. So I don't think the jury finds murder or voluntary manslaughter.
Well, I'll tell you, the defense doesn't want him found guilty of anything, and that's a big point that we saw yesterday. But before we play some of the testimony from yesterday, let's begin with the defense's opening statement, where you can hear for their own narrative of what happened and why they believe their client was acting in self-defense. Was the defendant just trying to save his life? Was he acting in self-defense? Brad, here's the problem, and you tell me. Is Mr. Carl Wimpy Jr. the innocent party here? Because we can't forget he left the bar and then came back in and threw the punch at Mr. Vasquez, which precipitated this. So how can we really side with the defense on there if he had the option to walk away?
That's the question I've been looking at as I follow the case, because when he left the first time, it's alleged that Vasquez threw some bottles at him. He could have just kept going. Richter. Right. He could have just kept going. Wimpy could have just kept going. But he decided to return. And that's when everything went bad. So I think the jury is going to be faced with a tough question of whether or not he should have left. And by his returning, did he actually then take more of an aggressive, more of an intentional stand to cause harm?
Okay, well, let's see what the defendant himself said yesterday on the stand about this. I mean, and we see it a lot of times in these self-defense cases, the defendant taking the stand and trying to explain his behavior. So Carl Wimpy Jr. took the stand yesterday. Let's see what he had to say. Okay, so what he's describing right there is the moments that he's focusing on Arthur Richter when Mr. Vasquez, he says, is the one who tried to touch him on the shoulder, tried to get him away, and he just reacted. So, Brad, we're left a little confused here. It's alleged by the prosecution he hit him 6 times. And that was ultimately what caused the death of Mr. Vasquez. Now we're sitting back and thinking, well, if he's in the middle of the fight with Mr. Richter and Vasquez comes up to try to break it up, he's in the middle of fight or flight mode.
Right.
Does the jury think about that and say, well, maybe that is reasonable what he did? How's he supposed to know who his enemy is and who isn't?
I think so, and he was a pretty good witness. He was fluid in his testimony, he seemed comfortable in his recollection, and remember that Vasquez was related to Richter. He was his uncle, so it's unlikely that he was trying to necessarily break up the fight as much as he was more likely to be trying to help or protect his nephew. So it puts more the burden on the prosecutor to say that Wimpy didn't have good reason to almost have to defend himself against these two men who kept coming after him.
In other words, if Vasquez was unrelated to both individuals, was just a regular bar patron, this might change the dynamic of the case.
I think so. I think it'd be more reasonable to suspect that maybe Wimpy was more aggressive than necessary, used more violence than reasonably necessary. But here, you can't doubt that Vasquez was going after Wimpy and not after Richter in any way.
Yeah. So again, I think there's a bit of confusion anytime you have these kinds of fights. Have you seen a case, and I want to go back to the voluntary manslaughter charge, which is something that we believe the jury may have an option to convict him of. Have you seen a successful prosecution of a manslaughter case in a bar fight like this, or a fight?
No. Usually a manslaughter case is going to come where you're doing something reckless, like driving or tossing knives, or something that you clearly shouldn't be doing, and a death results. If a death results from something that is reasonable or necessary, I don't think you get a voluntary manslaughter.
But isn't fighting reckless?
Well, yes, but they're claiming it was self-defense, and that's why the question that you asked before about when he left, when Wimpy left and then returned, was he necessarily in fear of his life, or did he have the ability to just go? Was he now the aggressor? And I think that's going to be pivotal.
I wonder how much they're going to take into the fact that he could have left, that he was outside the bar and came back in. I'm sure it's something that's going to be in their deliberations. We'll take a quick break, but when we come back, a lot more to discuss. So when the defense's expert was on the stand yesterday, they said that when Mr. Vasquez was thrown to the ground, that's really what precipitated the cause of the death. And their expert said that it was ultimately a stroke that caused the death, while the prosecution, the state's expert, said that it was blunt force trauma to the head. But more importantly, we're trying to understand Mr. Vasquez's role in this fight. Now, I'm back here with Brad Micklin to talk about this. And as we said, one of the options the jury will have is voluntary manslaughter. When you look at the statute, it says that no person, while under the influence of sudden passion or a sudden fit of rage, which is what you could say the defendant was under, but which is brought on by serious provocation occasioned by the victim, so that Mr. Vasquez is the one who brought on this fit of rage, that you can't, you can't, that would incite deadly force, which is maybe what happened. You can't cause the death of another individual. So the idea here is we place the impetus on Mr. Vasquez, so that he was the one that precipitated this causing of this violence. Is that the way I'm understanding this? And is that what the jury is going to ultimately see, that maybe they can get him on voluntary manslaughter?
It's going to be tough because, again, most of the fight was caused by Richter. So Vasquez intervened into that. So I don't know if we're going to be able to tie Vasquez as the cause of this passion or of this altercation. But I still don't think that the jury is going to be able to find that Wimpy acted in a way that either purposely, which is needed for murder, or knowingly, which is needed for voluntary, committed this crime and wanted it to or expected it to lead to murder. That's why everybody says intent's not required, but you still have to have purposely or knowingly done it. And I think that's a sort of an intention issue.
Well, I mean, I guess it's all how you frame the argument, right? And that's really what we saw yesterday from the closing arguments. So in case you missed it, here's the prosecution's closing arguments, why they say Mr. Wimpy Jr. is definitely to blame. Okay, so those were the closing arguments, and it should be noted that Arthur Richter Jr. Was found guilty of complicity to murder and inciting violence in connection with starting this bar fight, so he was not off the hook himself. Back here with Brad Micklin. Brad, as we wait for the jury ultimately to begin their deliberations today, I got to ask you, what do you think is the biggest hurdle for the prosecution, the biggest for the defense? And I know we only have a short time left.
It's hard to say without seeing that video. I'd love to see the video. The prosecutor's biggest hurdle is causation, that the assault led to the death, because the medical testimony is confusing on both sides, and I think that really helps the jury find not guilty. For the defense, there's a victim, there's a death, and he caused it. There's no question about that. So they have to find that he did it in such a way that he shouldn't be punished, and that's hard.
It's hard both ways, and the jury's ultimately going to have to decide one way or another. We're going to take a quick break, and when we come back, we're talking Tammy Moore. Well, Tammy wants to testify. I'm back here with trial attorney Brad Micklin. Brad, I got to tell you, what we've been seeing here is a question about whether the prosecution's case is strong enough to successfully prosecute on these kidnapping and conspiracy to kidnap charges. What good can come from her testifying?
I don't think any good comes from her testifying. Rarely does a lot of good come from a defendant testifying. I think it has something to do with the fact that we're told that her husband is going to be testifying. And since there's a conspiracy charge, it might be she's getting up there to point the finger first to avoid that.
Well, maybe. It's also possible he might be called as a rebuttal witness by the state. So doesn't it all matter what she testifies to? And I believe that is a live shot. Yeah, that's a live shot in the courtroom right now. So isn't that matter what she testifies to? So if she points the finger at Sidney, the prosecution's going to call him out.
I think so. But I think we would have heard from the defense attorney in the opening statement that it was going to go in some kind of a direction. I don't think that they're going to come with a big surprise and have Tammy say it was my husband without some kind of indication to the jury beforehand, because it would look like a sneaky lawyer trick. It's easy to get up on the stand and said he did it.
Right. I don't know. The Moores are fascinating to study. But it's not just Tammy Moore and Sidney Moore, and we saw the testimony of Irene Moore, Sidney's mother. But now let's show you what happened, because there were supposed to be the Moore children were going to testify, but they were sequestered witnesses. They weren't supposed to see anything from the trial, no live stream, no footage. There was an issue that they broke that order. So what we saw yesterday was the testimony from Deputy Jane Pike, who was the one who actually caught the Moore children, in her words, watching the live stream. Let's see what happened when she testified. Okay, so they're saying that the Moore children basically violated the sequestration order. Now, Brad, that's a big no-no, right?
Yeah, almost always in a trial, witnesses are going to be sequestered. It prevents them from being influenced by what other people have to say, and that you know that their testimony is going to be natural.
So what would be the danger of the children here in this specific case watching the trial?
Because we don't know who's going to be called to testify. I think one of the children were already called or was already called to testify. So you can't have anybody, even if they're going to have contact with other witnesses, you just can't have people being influenced by the testimony of other people.
Especially if you're, I mean, we're not, the children here, they're talking about their mother, right? So that's a big issue here. And we saw that yesterday, Christian Moore, who is the defendant's son, was asked about whether or not he violated this sequestration order, or whether or not he, watched this live stream. That became a big issue. So under penalty of perjury, under oath, what did he have to say? Okay, Brad, he denies watching anything, okay? Denies it. Then, when he's cross-examined, the prosecutor made a good point. He goes, there's cameras throughout this whole courtroom. There's cameras in the room where you were sequestered. You still saying, under penalty of perjury, you didn't watch the live stream because we could see what you were looking at. And he said yes. The judge didn't believe him and said that he violated the sequestration order, wouldn't allow him to testify. So I wonder if there's a question, could he be brought up on perjury charges?
Possibly. I thought it was interesting that the judge had the opportunity, had he wanted to review the tape before making this decision. And he's making a crucial decision because he's preventing a potential witness, whether it's a rebuttal witness or a fact witness, in a murder or not in a kidnapping trial. So the fact that he didn't review the tape suggests that he didn't believe him from the start.
Take it away, the sequestration order. If he was permitted to testify, what do you think he was going to testify to? What do you think these children were going to testify to?
It's impossible to know. I mean, this story is so crazy that, and the family, or at least the parents, seem so crazy that who knows not only what the children would say about their lifestyle or where their parents were that night, but we don't know, because children have such an incentive to lie to protect their parents, and we don't know what they would say and whether or not it's going to be believable anyway.
Because the relationship between Sidney and Tammy is the focal point here.
Right.
It's trying to understand, did she have control over him? Did she influence his decisions? Did she prevent him from moving at one point? I mean, it was an allegation that he came forward in his police interview and said she handcuffs me to the bed. And some of the evidence they brought out yesterday would show how that was impossible. My question is, we saw the day before this the testimony of her cousin, who came on the stand, said, I was shown a picture by Sydney Moore of Heather Elvis in a condition where she couldn't walk and she couldn't talk. People were wondering whether that meant she was bound or gagged, or whether she was incapacitated in some way. So I was wondering, when Sydney allegedly showed this picture to the cousin at a cookout or a barbecue or something like that, would these kids have come forward and said, well, wait a second, I never saw that, or let me tell you a little bit about this cousin?
It's hard to say, because the whole testimony by the cousin, the whole picture issue was strange. I'm assuming there was some kind of pretrial motion that prevented description of what was actually in the photo. So instead he described what he believed she could or couldn't do in the photo, which I also thought was strange because it's hypothetical. He's not certain, he's just guessing at what she could or couldn't do. And then it was questioned that he told his mother that he didn't see the picture, and then he said, well, I lied to my mother. So the whole picture testimony, I think, just threw a wrench into the case because it doesn't make any sense.
But in the prosecution's case against Tammy Moore for kidnapping and conspiracy to kidnap, we're wondering what their strongest piece of evidence may be. We'll talk more about that right after this.
Preview.
Right, so a little bit of excitement in the courtroom. When is there not excitement in the Tammy Moore courtroom, to be honest with you? I'm back here with trial attorney Brad Micklin. Brad, the idea of when he got that tattoo of Tammy on his stomach, and if apparently they can manipulate the dates of that post, that becomes a big issue for the defense's case and the prosecution's case, right?
Probably. I think they're using the tattoo as one example that she not only had severe control over her husband, but that she was really upset and enraged by the affair that he had. So if the tattoo was, let's say, long before she learned of the affair or long before the affair, then it has nothing to do with it.
Right. So, but isn't it suspicious? So if he got the tattoo after Heather Elvis disappeared, wouldn't that be even more suspicious than if he got it before she disappeared?
I don't know. I don't know if the tattoo, in my opinion, really has that much of a significance. I think the prosecution making it such an issue is just confusing. What does it have to do with whether or not she or the two of them conspired or actually kidnapped this young woman? It doesn't make any sense to me.
We talked about it before our last break, but what do you think really is the most important piece of evidence that the prosecution has presented for a kidnapping or conspiracy to kidnap charge here for Tammy Moore? We're not talking about murder. Those charges were dropped. What do they have on her for kidnapping?
I think, ironically, is the absence of a body. I think the fact that Heather's not here suggests that something happened to her. Why didn't she surface? Why aren't there some remains? Why isn't there evidence of where she is? Which is why I don't think we have a murder charge, because the whole case is circumstantial. But to have a murder charge is circumstantial upon circumstantial. It's first we have to assume there's a body and a death. Then we have to make the jury believe the defendants committed the crime. So you have two levels of problems here. With a kidnapping, it's almost understandable that you wouldn't have a body. And I think that's the strongest piece that they have, is the piece that they really haven't mentioned much.
But how do we know? So if you look at the statute, there's certain specific things that they either need to prove, that they seized her, they confined her, they kidnapped, some way that they had control over her. How do we know it's not a situation? If so, people out there think that the Moores had something to do with her disappearance. They lured her out to an area and they pushed her over the cliff, or into the alligator pit or crocodile pit, which is something people have said that's why there's no evidence of her body. That wouldn't necessarily be kidnapping.
Well, if that were the case, if that were the fact pattern, it might be kidnapping. I mean, abducting and carrying away could be in many different forms. But I think if the jury reads and pays attention to the statute, I don't think they're going to find that the Moores committed any one of these specific elements to it.
So that they're having trouble here in their case.
Yeah, it's a weak case.
And so the defense, you wonder, why are they calling Tammy Moore? Clearly, you would have to imagine she wants to say something. She wants to give the jury something else to consider. I'm wondering if we're getting in the makings of some really huge testimony today.
It could be. The most fascinating thing is that the defense attorney mentioned in the beginning of the case that she was going to testify, which is a horrible step to take, because the case could have gone so badly for the prosecutor that they wouldn't want to put her up. But then it raises a question of, to the jury, well, if she said she was going to testify, why didn't she? So normally you wouldn't even bring that out in the beginning because you can bring it out later. So Tammy, must be really just bent on testifying about something. That's why I'm dying to see it.
Right, because always they say you can't, to the jury, just because the defendant didn't testify, you can't use that as a factor in your deliberations. But the fact that you say, hey, she's going to come on the stand, and then she doesn't, that's a problem.
Well, plus jurors are human beings. They're going to wonder why they're not hearing from her. Even if she took the Fifth Amendment, or even if the judge instructs that she doesn't need to testify, jurors are still going to wonder why she didn't. It's just human nature. But when you say she's going to testify and then she doesn't, it forces the question.
Yeah, jurors are human beings, and they don't miss any point. All right, we have our first witness of the day. Let's go live. Welcome back, everybody. We're live in the South Carolina courtroom, and this is the trial of Tammy Moore. Sydney Moffitt is on the stand. She lived with Heather Elvis, the victim, at a certain point in time, and she came to live with her because Heather's boyfriend at the time, Jeremy, was apparently beating up on her, and she had bruises and didn't want to go live with her family because she didn't want her parents to know about the abusive relationship. She was just asked under cross-examination, did you know that she dated Sydney Moore? And she says, I didn't know anything about this relationship and didn't know that Tammy was apparently threatening her. So again, I'm here with Brad Micklin, trial attorney. What's the value of this witness, the value of this testimony?
I think the reason that she's called is I think they're trying to give some reason to the jury of why this young lady might have disappeared. If she had an abusive boyfriend in the past and maybe he resurfaced, she would flee. Because I think once the defense took the step of putting on a defense, they have to answer that question of, if she's not here, why wouldn't we hear from her?
So in other words, that perhaps she just went missing. Perhaps she went up. So we've seen these cases before where there's no body. Shouldn't the prosecution put in some evidence to say, here are statistics out there of people who have gone missing? And how many people have gone missing? There is absolutely no trace of them whatsoever. No cell phone records, no camera footage, nothing out there, which would indicate to somebody that a person didn't go missing and escape. They went missing because they were killed. So, I mean, how much of that evidence should be put in here?
I don't think any of that evidence should go in. A statistic about whether people go missing or are murdered really isn't relevant to whether or not Tammy Moore and her husband did anything unlawful here. But I think the bigger question that the prosecution should have presented, or the bigger issue they should have, is that she had no reason to leave. She was a young girl, she had some friends, she worked in a restaurant. Why would she just pick up and disappear?
That's a great question. All right, we got a new witness on the stand. We're going to learn a little bit more of this story. Let's go live into that South Carolina courtroom. Brad, what's the purpose of this witness? I'm not really sure I'm getting much from it.
I'm not sure either. And if we're sitting here uncertain, the jury's baffled. The only thing I could surmise is maybe they're just trying to put so much information that the jury gets confused, or they think, well, that was reasonable doubt because we don't know, we don't understand. Otherwise, I don't see any purpose behind it.
Yeah, he doesn't really know Heather Elvis that well. Didn't know her relationship with Sydney Moore. Didn't know about her relationship with Tammy Moore. And really didn't have that much contact with the victim. So we're all wondering what the purpose of this witness is. It should be noted that the defense's case was kind of undercut a little bit yesterday because they wanted to call the Moore children. They were not permitted to testify because of violating that sequestration order. So I wonder where they're going next in their case.
Hopefully to Tammy.
That's what we're all waiting for. We are waiting for Tammy Moore to take the stand. I believe we have to take a quick break, so we're going to do that right now. Okay, I'm here with trial attorney Brad Micklin. Brad, when you call a witness, there's a purpose.
You would hope.
What's the purpose here?
I don't know. And the worst part about it was nobody here in studio had any idea what this witness was about until the prosecutor's cross-examination. Then it seemed to suggest that maybe the defense was trying to suggest that he kidnapped Heather.
So why not call me to the stand and say that I had something to do with it? I mean, again, what's the relationship? There's no real relationship. Is it just anybody that had contact with her? It makes no sense. Why would they do that? Doesn't that hurt their case, the credibility of their case?
I think so. I think it looks like a lawyer trick. If you're going to call a witness to suggest that this witness may have committed this heinous crime, you want to be able to show it pretty clearly. You don't want, obviously, he's not going to admit, yes, I kidnapped her, but you want to be able to tie together either by testimony or by impeachment that maybe he was the person who did it, not to just suggest it, which is what they weekly did here.
Who are they going to call next? The pizza delivery guy that delivered pizzas to her apartment? I mean, really, like, I'm not sure I get it, because, again, we're talking about how can't they just win a successful case based upon the prosecution not having a lot in theirs?
I think so, and if they hadn't opened the door and started this case down this road, they wouldn't have to. If they had just moved after the prosecution's case, say they didn't prove beyond a reasonable doubt, because remember, it's beyond a reasonable doubt, and there's a lot of doubt here. But now they're opening the door to all these issues and making the defendant look worse with each different witness that they call.
Now, we are waiting to see if she will be called to the stand. It appears what they would do if they want to call her, she's going to testify as the last witness. Is that what you're seeing? I mean, they're calling these other witnesses. Why not have her start the testimony? Or is it more strong and more compelling for her to be the last witness, the last thing that people hear?
I think it's compelling for her to be the last witness if she has something meaningful to say and if she's a good witness. I don't anticipate she's going to have either anything good to say, and I don't think she's going to appear as a good witness. It's a bad case for them. There's an ugly situation. There's her husband, which I'm sure the jury doesn't know, that's already in prison for this, and there's a woman missing. No good comes from Tammy getting on the stand to try to clarify it.
Yeah, he's in prison for 10 years for obstruction of justice. His kidnapping trial ended in a mistrial. All the murder charges were dropped against him and Tammy. We have a new witness on the stand. Let's maybe see if this witness has a little bit more to say. Okay, we got to talk about what the defense is doing right here. I'm here with Brad Micklin. After seeing the testimony of Timothy Tyndall, who really didn't add much, now we got a guy who comes on the stand who says, I thought I saw Heather Elvis after she disappeared, but I was wrong. What's going on here?
You would think this would be like that quintessential smoking gun where, isn't it true you kidnapped her? And it's how it seems to be presented, that they wanted to show that he saw her the next day. But the way it's being presented and the questions that he's answering suggest that he was mistaken, that he said it was Saturday, but it was Friday, and there was a video that there was a tattoo or not a tattoo, and I guess there was a timing issue when she got it, that it couldn't have been her or couldn't have been that date. So what could have been this big smoking gun just looked like a big waste of time.
The idea of what the defense is doing is trying to raise reasonable doubt that perhaps she was not kidnapped or killed, but something else happened to her.
Right, but that's such a mistake, though, because it's not the defense burden to raise reasonable doubt. It's prosecution's burden to prove beyond the reasonable doubt that she was kidnapped, that Tammy abducted, carried, and detained this person. A lot of people think that. It's common to say, well, the defendant's raising reasonable doubt, but it's not her burden to do that, and she shouldn't even be trying to.
So is the defense want to say in their closing argument, they say she has a presumption of innocence, the prosecution hasn't met that burden. And one of the reasons why is, look, you have one witness who said maybe he saw her, you have another guy that knew her, and maybe that's reasonable doubt that there's something else could have happened to her, but is this just not an effective way to do it?
I think it's both. I think that they're going to use this as a closing to say there's so many different options here, we don't know what it could be. But I think that's a mistake, because what I think they're doing is, instead of just presenting to the jury, hey, we don't know what happened here, they're almost suggesting that something bad did happen, but it might have been these other people that did it. And you don't want to send the jury back with that kind of a message, because then they're going to want to make somebody pay for that. And that would be Tammy.
Yeah, and we're all wondering when or if she will take the stand. That's what we're all waiting for Tammy Moore to take the stand in this case. We're going to take a quick break. When we come back, we'll be live in that South Carolina courtroom. Okay, so you might be wondering, why is this witness coming to the stand? Well, our producer is telling us that in Sidney Moore's trial, there was a whole discussion about whether or not Tammy was in fact pregnant, and perhaps these records would show that, because that becomes a big issue in terms of that pregnancy test. You remember that there was a question of whether Heather Elvis was pregnant. So Brad, if that's the question of whether Tammy was pregnant, it could explain away some certain motive, I guess.
Yes, certainly. I mean, I think it's a big piece. I'm not sure if this witness is here to say that Tammy was pregnant, or they're here to say that Sidney tried to suggest that Tammy was pregnant and may have offered false records to do so, because I think he was sentenced on an obstruction charge. So I don't know if that was what the nature of it was. I know his truck was sold afterwards. So I'm really curious to see what records she's here about.
Okay, let's go live and we'll learn a little bit more. All right, so we're getting an idea here of what the defense is doing, trying to explain away some of the evidence put forward by the prosecution, including the fact that Sydney Moore bought this pregnancy test at Walmart. We presumed that it was for Heather Elvis, because if she was pregnant, it would give him perhaps an incentive or a motive to get rid of her. And you would see that Tammy obviously would be upset about it, and you can get the story. But if Tammy was the one who was really pregnant, then maybe there's a different story here. Brad, what's your perspective on this?
I think so. I think this is probably the only witness so far that might actually help the case. If the prosecution is going to really rely or strongly rely on the fact that he bought the test because Heather was pregnant, that would give Tammy motivation and motive to want to kidnap her. And that might explain why Tammy's getting on the stand. Tammy might get up and say, no, we were trying to get pregnant since 2012.
Yeah, and so he bought this test and then went right to the payphone to call Heather. That could be a suspicious move. On the other hand, you could look at it and say, well, wait a second. Maybe Tammy finally let him out of the house. He gets this pregnancy test and calls Heather to explain the situation that, hey, she's pregnant, or we think she might be pregnant here.
Yeah, the phone call is strange because it still does suggest that he bought it for Heather. But hopefully we'll find out either through the records here or through Tammy when she finally takes a stand.
Yeah, I want to confirm right now that, yep, we're going to take a quick break, but when we come back, we'll be live in the courtroom. Stay tuned. Okay, so just if you're joining us, Tammy was in custody when she was taken to the ER and had this pregnancy test. 2 days before that, she had been in court asking for a bond, saying that she was pregnant. At the time, the prosecutor said they didn't know if she was really pregnant, so and that she had refused the test. Again, back here with Brad Micklin, trying to understand, don't they have bigger issues to tackle here than the pregnancy test? Or really, that's an important factor. I'm curious what you think about the pregnancy issue.
I don't know. I keep going back and forth as we get further into it because on the one hand, maybe they're going to argue, the defense is going to argue that she was pregnant 9 months earlier and that's why the husband bought the test. Or it could be that she was pregnant 9 days earlier and she had an affair with somebody while she was incarcerated. I have no idea where they're going with it.
And again, we're all focusing on this because it was believed that Heather Elvis may have been pregnant at the time of her disappearance, which would have given Tammy more incentive or motive to make sure that this woman who had an affair with her husband and had her baby would have a reason to get rid of her. Let's go live. Okay, so this is getting even more bizarre, putting the prosecution in the hot seat, trying to explain this whole pregnancy issue. Again, we're trying to see who was pregnant. Was it Heather Elvis? Was it Tammy Moore? Was Sydney Moore buying a pregnancy test for Heather or for his wife? One thing that should be noted is that there was a statement made by Sydney Moore where he said that he was buying that pregnancy test for his wife. This came out in his trial. And that he said his wife was in the car when he went into that Walmart to buy the pregnancy test, which is strange because we know that right after he bought that pregnancy test, he went on a payphone and tried to call Heather Elvis. So Tammy was in the car while this was happening. Again, very bizarre thing that's happening here. I'm back here with Brad Micklin. We knew today was going to be bizarre. We thought that Tammy might testify, but this is just a different kind of line of testimony.
Yeah, and they keep spending so much time on it that you think it's going to become relevant. And I don't have any idea what Sydney's statements, if they're even going to come into here, would have anything to do with it, because we can't really trust what he's going to say about any of the situation. But none of it makes any sense. And maybe, again, that's why they're planning to bring both husband and wife to testify and clear it all up.
We saw at the beginning part of the testimony, there was some indication that the defense was trying to say that perhaps Heather Elvis is still out there. We talked about it a little bit earlier. Do you think that they needed to expand upon that?
If they raised it, they probably should have expanded, because I think it's a mistake to raise that. It's not believable that she's out there somewhere and just remained silent for all these years from her friends and her family, and now that there's a murder trial before and there's a kidnapping trial now and she's just remaining quiet. It doesn't make any sense. They shouldn't have even brought it up.
Yeah. This is just, and you see these pictures of this young girl, beautiful young 20-year-old girl, never seen from again since 2013. How eerie are these kinds of cases when we don't have a body and we don't know what happened? I mean, there's always some kind of evidence, always something that can point to what happened to somebody.
Yeah, and that's the worst part about this, is the jury's going to be sitting there saying, what happened to her? Not only do we have to decide if something happened to her, but we have to decide, do we punish this woman, Tammy, because we think she did it to her? And you're always sympathetic when somebody goes missing, especially a young girl like this. And it leaves the jury kind of pressured to try to do the right thing, and nobody knows what that is.
When you don't have a body, is it easier to prosecute a murder case or can kidnapping and conspiracy to kidnap case? Because we know that the murder charges against the Moores were dropped.
I think it's harder to prosecute a murder case without a body, because again, like I said earlier, it's circumstantial and upon circumstantial. Kidnapping implicitly suggests you want to have a body, because if you did have a body, the body would either be dead, which would then be a murder charge, or the person would be alive and testifying to the kidnapping. So the absence of a person, I think, actually strengthens the prosecution's case.
We know that this trial is going to extend into next week. We're waiting to see if Tammy Moore will take the stand today, but we're also waiting to see what other witnesses will be called by the defense, if any. What kind of witnesses do you think they need to call, if any?
I don't know. It depends. I think the bigger question is going to be next week after Tammy does testify, assuming that she does. What rebuttal witnesses are they going to be bringing in? Is there going to be other records that come in, other people that Tammy may have spoke to when she was incarcerated? None of this would be necessarily relevant until she takes the stand.
And I suppose there's a question of whether or not the Moores, Sidney, and Tammy will have a united front, or whether they'll point the finger at one another.
Which would then go possibly to the conspiracy charge, though.
Yeah, I mean, this could get very messy in the next couple of days.
Right. And the husband, I think, can still be tried again.
Yes.
So it's unlikely that he's going to expose that, because if he gets up and says to Tammy, or says Tammy did it, he knows she's going to say he did it, and then he's likely to be prosecuted again for it.
It's like a bad Lifetime movie, I'll tell you that much. Brad Micklin, thanks so much for coming on. It was great to have your perspective, and you got to come back here soon.
Thanks for having me, Jesse.
Of course. All right, everybody, we're going to take a quick...
Well, you have a prediction on the Manafort trial?
I think he might be not guilty, because this whole thing is so many twists and turns and so much hype and expectation that I don't know, but I am curious to see what happens if he's not guilty. What happens to the Mueller investigation?
I'm not going to make a prediction until we hear from our next guest, and that is Brad Micklin.
That is a trick question, David.
Brad Micklin is an attorney who joins us here in studio. Brad, I'm going to ask about Manafort in just a sec, but the other topic that's sort of swirling out there involving President Trump and his defense team is this issue of collusion. The president has now said no collusion, but if there was collusion, it's not a crime. Right. Technically, he's correct. There's nothing in the federal code about collusion, but doesn't that miss the point? I mean, if you work with a foreign national and you get something of value to your campaign, that's against the law.
Yeah, I agree. I think he's playing semantics with the American people, and when it comes out, it's not going to be well received, because collusion is just planning to defraud, where conspiracy is planning to do something unlawful. So it's a word choice. So instead of using collusion, we spell it as conspiracy, and we have a crime. So I don't think it's going to really fall too well if that does later come out that there's a conspiracy.
Right, the crime is the conspiracy. That's on the books as a crime, and collusion, the word collusion is not on the books.
So technically,
but it's the same thing.
Yeah, I don't think the statutes across the nation use the word collusion, but they certainly do use conspiracy.
But to be clear, if somebody colludes or somebody works with a foreign national in your campaign, and it's to do something that is not of, say, value to your campaign. Suppose they were talking about policy, that is legal. So even if they had a meeting at Trump Tower or wherever they did, and they're talking about, okay, here's what our policy is going to be, as long as the Russians are not providing some benefit to the campaign like dirt or money, that's legal.
Sure, but you can conspire to do something that's lawful. The key is doing something unlawful, which is why it's an important point. Everybody's talking about that there's supposed to be no tie to the Russian investigation in the Manafort trial, but that's actually not accurate entirely, because I think there was a pretrial decision that states that there was one conversation with a bank officer where he was promised influence in either the campaign or after the election. So there's going to be a thread that's going to tie this Manafort trial possibly to the collusion and the Russian investigation.
Let's talk about the trials. 12 jurors, 6 men, 6 women. How could anyone guarantee that they're impartial given the wall-to-wall coverage of the Russia investigation?
I don't think anybody can be completely impartial. I mean, you're hoping that you're as impartial as possible and that you can separate the facts from your own personal beliefs. But everybody from the judge to the jurors to the attorneys, they're all people. We're all going to go in with our preconceived ideas, and it's going to influence how we view the testimony and the ultimate decision.
I was struck that the prosecution estimated this trial would only last 3 weeks. Normally, these kinds of fraud and tax trials are at least 2 months. Is this an indication that prosecutors are aiming for a very tight, narrow case?
It's hard to say. I think that this case is almost like killing a fly with a sledgehammer. They're going in with 18 different charges in 2 different states. There's no way that they can have this done that quickly unless they're going to just present a lot of documents that are going to be boring and dry for the jury. But they must be very clear that that's what they have, because they're putting them on for 305 years of sentencing.
Manafort's right-hand man, Rick Gates, he turned state witness, and the defense already is arguing that he's an unreliable witness. Do you see him testifying during this court?
I believe he will be testifying. I think that's part of his plea deal, was that he's going to testify in return for leniency in his sentencing. Not really sure what his sentencing was inside the plea, but I'm almost certain he's going to be testifying.
And the strategy with the defense knowing that Gates is going to be a prosecution witness, and on their first day in opening arguments, the defense said Paul Manafort didn't know what Rick Gates was doing. This was all Rick Gates that was lining his own pockets. Paul Manafort was oblivious to it, didn't know. Paul Manafort was there traveling around the world while Rick Gates was cooking the books, essentially. Is that a good defense strategy when you know, okay, the entire prosecution case, not the entire case, but a big part of it is going to rest on this prosecution witness? If you can get the jury to focus on that prosecution witness and away from your client, is that helpful?
I think so, and I think that's the whole approach. I think that Mueller's looking to make this like his first big domino to fall. And if he can get Gates to testify against Manafort and he can get any kind of conviction out of these 18 different charges, then he can at least say, we did something, we were successful, and then go move on and have political clout behind it.
But as far as the Manafort defense strategy, for them to pin so much from the beginning on discrediting Gates as opposed to necessarily defending Manafort?
I don't think they have much other choice, because Gates is going to go up there as his partner and testify in some way or another that they committed these crimes and that he knew about it. The only way you can do that as a defense attorney is to discredit the testimony in the first place. I think that's what they were trying to do in their opening arguments today.
We know the president loves to tweet. He loves to tweet about what he calls a witch hunt. If he tweets out about this court case, is there any legal issues that he might be trying to influence the judge in this case?
I don't think so. I mean, he has been unusually quiet, but I don't think that any tweet that he's going to make is going to influence the judge, and I don't think there's any way to stop him from doing it anyway.
I asked Michael Schur at the top, and it was sort of a joke about what is a, ostrich feather jacket. But this does feel like, a lot of trials, in order to make it relatable to a jury, you put something in there about the defendant that is way beyond what most normal Americans can conceive of, and that is a $15,000 ostrich feather jacket. And right from the start, you're painting the defendant as somebody who's not like you and me.
Well, also, and I agree, but I also think they're trying to make him look like he must have been doing something to maintain this lifestyle, because the facts are that he was very successful at a point in time until around 2014, and that's when it dried up and he started with the bank fraud. So if he had this lifestyle in place already and his income dried up, then he had to do something to maintain it. And I think that's where these pieces are going to come in.
And the argument is also he signed on for free to the Trump campaign because he thought he might get some more business dealings once that happened and Trump lost,
right,
which he didn't. All right, Attorney Brad Micklin, always a pleasure to have you on. Thanks for your insight.
And based on what Brad says, based on what he just said, I'm convinced now that Manafort's going to be found guilty. Let's bring in now Brad Micklin, a trial attorney, and Alice Hennigan, a columnist for the global Metro papers called Trump's America. He's also the author of Trumpitude, The Secret Confessions of Donald's Brain. Alice, what was your reaction when you heard that?
Thuggery. It's the word that applies to both of those things. By the way, I can't believe you could read that prompter about that fist fight inside the consulate there with such a straight face, David. I mean, come on. We got to call this stuff out for what it is, right? Unacceptable, abusive, inappropriate, whether it's going on in the consulate in Turkey.
Talking about the consulate on the president's
Well, you know what? You want to know? It's a really good question, because kind of I'm talking about both. I'm not saying they're the equal, but I will tell you that kind of language out of the President of the United States sends a message to bad people around the world, and it says you can get away with this kind of stuff, and we're not going to call you on it. Shameful on both sides.
Was it simply a joke?
I believe so. I mean, of course, I disagree. I think no matter what he would say, he'd be criticized. If you support him, then you think what he said was unjust. If you don't support him, you criticize him. He was making a joke of it. And while it's not appropriate possibly to joke about an assault, especially when I'm talking to news reporters, but the man served his time. He pled. It's something in his past, and it's time to move past it.
Well, Alice, it's never okay to assault reporters, but,
Anybody. Anybody.
And even the congressman, he apologized for this incident. But what President Trump did do over the past 2 years is change or break the cycle in which the media can criticize policymakers, but policymakers can say nothing.
No. I mean, people have a right to criticize each other. I'm talking about making violent threats, dumbing down this kind of commentary. And frankly, I mean, listen, we're all old enough to remember when a president behaved presidentially. And the idea of promoting body slamming of reporters, or even worse, turning a blind eye to the kind of brutality that is almost unthinkable. I mean, try to get your head around the idea of somebody being chopped up inside a foreign consulate and then chopped up with a bone saw. I mean, if that doesn't make you outraged.
Is it fine to say fake news?
Fake news? No. Every single piece of it is real.
But here's
news.
what I don't understand, Brad. I mean, look, fake news is one thing. Actually encouraging somebody to be body slammed is another. Why is it that the president can't simply say to those media, look, I don't like those people in the back of the room. They don't give me a fair shake. Those reporters, they're biased. All that's fine. But to have to go and say, and I love this guy who body slammed a reporter. I mean, it does cross a line, doesn't it?
I don't think so.
Really?
I think Hillary threw down a gauntlet when she said we can't be civil unless we win. I mean, how was it appropriate for her to say that, but not
But she
Trump
wasn't singling out a specific case of violence towards a reporter.
I don't think he was singling out a case of violence. I think he was supporting an individual who had been found.
Who had a specific case of violence against one single reporter.
Right, but I think he was supporting him, not his act. It just.
Brad, why isn't it possible for Trump supporters to say, you know what, we like the guy, we like the people he's putting on the court, we support these policies, but some of this stuff he says is just wrong.
Because
I wouldn't want my kids to do it, and I don't want my president to do it.
Because they won't say that. Those that support him will support him, and those that don't will crucify him no matter what he says.
Why don't you say
I did say that.
That it's wrong.
I don't think it's wrong to support an individual because he didn't act poorly in the past or committed. Look, if you knew about my past, you probably wouldn't have me on the show. But we can't.
Really?
We can't crucify a person for our past.
Move over here. No.
Let's have a different conversation.
But again, there's a distinction that's made, right? I mean, we're not talking about what happened 15, 20, 30 years ago. We're talking about what Donald Trump said Thursday night.
Yeah, and I agree. Look, I would prefer to have a president who spoke more presidential.
Good. Okay.
I grew up with that. I'm used to that, and I encourage it. But we don't have that. At least we have somebody who speaks, and we know where he's speaking from. We know what he believes and what he doesn't believe. And if you support him, you can stand behind him. If you don't, you can stand against him. But at least you know where you need to stand.
And people are really sick of politically correctness.
Well, listen,
the president, I'm not saying that, of course, these comments are okay. Of course not. But standing there and hearing the president saying, you know, things in his own style tells people it's fine not to be so politically correct anymore.
This is not that complicated, right? We all have friends and family, people we love and care about, and sometimes they do bad stuff, right? And what we say is, we like you, we love you, but don't do that. That's not good. Shut up. For some reason, the supporters of the president, the real base of the president, finds it impossible to say that. I wish they would.
Well, I think a lot of people also wish that Donald Trump would leave it at, oh, you remember what Gianforte did last year, ha. I mean, maybe there's a joke there, but then to go and take it further and say, and that's why he's my guy, because of how he... And there's Donald Trump actually demonstrating. I mean, and I don't think people see a distinction, therefore, between thuggish behavior and somebody who's making a joke. In any case, Brad Micklin, a trial attorney, and Alice Hennigan, Trump's America columnist for the Global Metro Papers, thank you both.
Well, the high-stakes showdown between Supreme Court nominee Judge Brett Kavanaugh and his accuser, Dr. Ford, culminating yesterday in a tentative agreement. Ford's attorneys saying she accepts the Senate's request to tell her side of the story, but the actual terms, they're still up in the air. Here to weigh in on how this will and should play out is our a panel of legal experts, attorney Brad Micklin, legal affairs reporter at the Washington Times, Alec Swire, and trial attorney Eric Weitz. Thank you all for joining us this morning. Really appreciate it. Brad, let me start with you. I presume a Republican or rightward leaning in this process, do you feel like it's been done properly?
It's hard to say because it's still playing out, but I think there's been a lot of delays and people are becoming suspect of what's causing the delays. Like even a moment ago, there was a spot that there's an agreement to testify, but there's really not an agreement to testify because the terms are unclear. So nobody really knows where it's going to go from this point.
Quickly, each of you, how does this play out over the next week? Does Brett Kavanaugh get confirmed? We'll start with you, Brad.
I believe the judge will be confirmed. This is an act that alleges to have occurred when he was a juvenile, and fundamental to our system of juvenile justice is rehabilitation. And for him to have rose to this level, to be nominated to the Supreme Court, suggests that he's been rehabilitated, if in fact it is true. So Eric. I don't think there's any problem with this confirmation.
Brad, Eric, and Alex, thank you for your expertise. Good stuff. Appreciate it.
Thanks for having me.
know, you might scratch your head if I told you that Aretha Franklin, Abraham Lincoln, Kurt Cobain, and so many others have one thing in common. Aside, of course, from being American icons, all three of them died without wills written at the time of their death, and they are far from being alone. In 2016 Gallup poll, it showed that 44% of Americans have a will prepared. That means the rest don't. Joining me now, Brad Micklin. He is a family law attorney, and Carol Roth is back with us as well. Now, Brad, you do this on a more personal, face-to-face level. What are the impediments? In other words, when someone finally comes to see you and you say, what took you so long? What do they tell you?
Well, they have a lot of different excuses, and we see even with the long list of people that you name, because don't forget we have Prince also, whose litigation is still ongoing regarding his estate. So we have Prince, we have the Queen of Soul. It's like the royal family of music, and nobody's giving good advice. And I think the main reason for these kind of people, the people in their inner circle like to stay in their inner circle, and nobody likes to talk about death. So if you have a high-profile client who doesn't like to talk about death, you're not going to do it. But what you're doing is you're leaving their friends, their family, and even yourself with a slew of problems, both tax and legal problems that they're going to have to deal with.
When these things are publicized, do you see at least a temporary bump in people on your phone? Does your phone ring a little bit more often, or do you see an increase of people coming to your office?
Maybe. It's hard to say. I mean, there's certain times of the year that people get more litigious and more concerned. Holidays are always a big time. Summer's a big time. But I don't think these kinds of issues really prompt people to get over their fear of talking about death.
And final words of wisdom?
Final words of wisdom is on this commercial break. I want to make sure that you have a will.
Okay. You bring a kit for me?
I'll bring whatever.
And a future file system.
Well, you know what? It is a very serious issue, and it rips up families, and it's unnecessary, but it happens far too often. Thank you both very much. Really appreciate it.
To help us break down the legal aspects of all of this, trial attorney Brad Micklin. Brad, the Senate is not a courtroom, but this certainly looks like it's going to be a trial. You're a lawyer. We've got no corroborating evidence on both sides. We've got the testimony that both sides are going to say tomorrow. They've already put that out, the prepared testimony. As a lawyer, what would you be looking for?
Well, it's a challenging question. In a case like this, there's always a lot of balancing interests. The victims that are coming forward, they have rights to be protected and to have their time in court and to be heard, and even in this process. But so do the accusers. Brett Kavanaugh and his family, they also have a right to be heard. They have a right to be defended. And we can't lose sight of the fact that our country promises innocent until proven guilty. And that's going to be the first thing that I think we need to look at.
What would due process actually look like for both sides?
Well, that's another challenging question because it depends where we are. In the confirmation hearing, some people question whether or not it's even appropriate to be talking about these issues. If there were assaults, there's a criminal process. I believe in Maryland, where the first allegation from Dr. Ford originated, has no statute of limitations on certain sexual assaults. So due process would be in that forum. So depending on what we hear tomorrow, not really sure where the next step will be.
Brad, last question to you. One of the accusers has signed an affidavit. How does that change things?
Well, it puts a little more seriousness behind it, although I didn't get to actually see what the affidavit stated, but it's putting under oath a penalty of perjury, where a lot of the allegations that we've seen, where they originate from, as well as the ones that have surfaced just recently, are by other people. They're coming out either through their attorneys or through their spokespersons. We haven't had too many people that actually testified, which is why tomorrow is going to be such a crucial hearing.
Oh, and we're all going to be watching that, certainly, as is the President of the United States, who mentioned that several times at that press conference. Dan Revives, Dave Langford, Brad Micklin, thank you all for joining us on this.